will find there are no weird rules. You can't breathe out of the left side of your mouth. You have to raise your right hand. As long as you aren't distracting other folks in the courtroom, you can have a laptop or a tablet or an abacus. It's really up to you.
Thank you. So, judge in Florida, I was a DA in Fort Lauderdale for 15 years before I came to Georgia. And there was one judge who I adored. The first time I came to court, I put a box on and goes, Michelle, I'm like, sorry. So he taught me to ask.
All right, let's get on the record. This is 18 SC 162373. It's State versus Avante Hinton. Mr. Hinton is here in person this morning. Good morning, Mr. Hinton. He is represented by Ms. Young, who is also present in court. Ms. Convery represents the state. She's here, so we've got everyone we need to work through a motions hearing / status hearing in this case. I entered a scheduling order in, I think it was May, that set down some specifics about which I had questions and matters I wanted us to get closure on. I am anxious, maybe not quite as anxious as Mr. Hinton, but I am anxious to figure out what's going to happen with Mr. Hinton's case. He has been in custody for an exceedingly long time. He has all sorts of charges that have now been lumped into a single indictment. That'll be one of our topics of discussion today, severance of counts. But whatever we're going to do, it is time to get closure for Mr. Hinton, whether that means it's a plea to some counts, it's a plea to all the counts, it's a trial for some counts, and then the results of that trial dictate to the parties what happens with the other counts, or a trial of all counts. But we are very much in the position now to conduct in-person jury trials. And so the obstacle to getting closure for Mr. Hinton and for the several victims and family members in this case is now just getting everything organized, because we have courtrooms and we have jurors, and we ought to be able to get this case to whatever the final posture is going to be. And today will be a big step in that direction. Ms. Young, you mentioned that you and Ms. Convery had been having some good discussions. I know you've been with the case the longest of anyone here in court. You weren't the original attorney for Mr. Hinton. I know Mr. Smith had it for a while, and then Ms. Young, you and Mr. Gavin together were working with Mr. Hinton. I think Roderick Bridges at some point was involved, but you've been with the case for a while, so you're going to be our historian. I'd be happy to get an update from you too, meaning the two lawyers, as to where we are. And then I've got some items I want to cover. I'll note that we've got a sergeant here from the police department who we need to get on his way. So if he's going to be testifying about something, I'm probably going to prioritize that. over some of the legal argument I want to hear today about demurrers and severance and things like that. But first, I'll start with you, Ms. Young, if there's anything you want to get on the record up front about where you feel like the case is or isn't.
Thank you, Your Honor. Your Honor, could I request the name of the sergeant that's present?
Looks like Sergeant Young to me. Yeah.
Congratulations. I don't think you were a sergeant last time.
That's how old this case is.
And Your Honor, if Sergeant could step outside while we discuss the case.
Sure. Sergeant Young, you're welcome to go in the jury room if you want to go in there, or you can go out in the hallway, either way. We won't forget you. All right.
Had he not been wearing a mask, probably would have recognized the judge. So, Your Honor, in terms of process,
I need to make sure because I can't see it because your box is there. The microphone on your desk, does it have a red light or a green light?
Red light.
If you put your finger in that little indentation.
Green.
Green is good. All right.
And Judge, would the court prefer that I move the box?
I'm not like that other judge. You can have the box wherever you want.
Thank you, Judge. So in terms of process, the last time that Mr. Hinton and I were in court, the case was assigned to Judge Reeder. That was September 25th of 2019. And there was, after the court's ruling, I believe in October, within 30 days, the state filed a notice of appeal and an appeal was taken, as the court knows. And that took a year. So in terms of the progress of the case, although it is an older case, a year was pretty much for the appeal, which I believe the Georgia Supreme Court handed down their ruling, was it August 20th of 2020, thereabouts? And then, of course, we were in the middle of a pandemic, for the record. So there have not been court proceedings on this case since that time, in large part, I believe, because of the pandemic. There was a status conference or two between August and I believe December 17th of 2020. Mr. Pinson and I, Mr. Pinson being the prosecutor at the time, who I believe is now the chief assistant in juvenile with the Fulton District Attorney's Office, had, I believe, a telephone conference with Your Honor as to status and next steps. And that was December of 2020, I believe December 17th. And Mr. Pinson and I were requesting time to meet with the new administration, which was coming in January. That did not occur in terms of meeting with the new administration, but I have spoken with Ms. Convey. I want to say with Kara. I don't know, I would just feel very friendly, which is always a good thing. In the past couple of weeks, we've been trying to connect. We did speak yesterday and we've spoken previously. So communication has not been an issue. I believe that based on the conversation yesterday, that there are significant negotiations that may take place, and we're hopeful, as I was previously with Mr. Pinson, that these cases will resolve themselves by way of a negotiated plea. Certainly that will take up a lot less time than the motions, but we're not ready to do that today. To go back for a moment, back in September of, August 30th of 2019, if I recall, Judge Reeder had instructed that we file basically a recitation of what motions were pending, what motions had been filed. Additional motions needed to be filed by the 30th of August of 2019, which were done. And the main motion that was heard on the September 25th, 2019 court date was the Jackson Deno, which of course Judge Reeder granted and the Supremes confirmed. So a large bulk from the defense's standpoint of the evidence in the homicide is gone. There are, I believe, 4 other cases that had been, not to speak to the motions, Your Honor, but there were 4 other cases which were consolidated by way of indictment by the district attorney's office. And since that time, in the past month and a half, I believe, since April, Mr. Hinton has picked up a new charge. at the jail.
An unindicted case. It's now indicted.
It is.
He will send it this way.
Yes, Your Honor.
What are the new charges?
I believe it has to do with a cell phone, allegations of a cell phone. I haven't seen the discovery. It's been sent to my office. I believe it arrived yesterday, but I'd already left for the day, so I'll be picking it up after court today.
Will you be representing Mr. Hinton in connection with that?
If there's going to be a plea, Your Honor, I'm happy to do it as a courtesy to the client and the
Okay.
court instead of bringing somebody else in.
Yep.
But I have not been formally retained and I haven't seen the discovery, so, nor spoken to Mr. Hinton about it.
Okay. I just found it. Keep going. You can get it on the record.
21 SC 177772.
Right. One count, possession of prohibitive item by inmate. So, and it is currently with Judge Cox. I'd give that just a few more days before it comes here.
And then, in terms of the court mentioning Mr. Bridges, to my knowledge, Mr. Bridges has never spoken to Mr. Hinton. Has he ever? No. Has never appeared in court. Rachel Ackley had been the C3 attorney on Mr. Hinton's other cases other than the homicide. When the state re-indicted in, I believe, October, November of 2018, all of the cases came together with the homicide. And at that point, I had not been hired on those cases. So it created a bit of a logistical problem. I spoke with Ms. Ackley. I believe she's employed elsewhere now and no longer a C3. I can tell the court, which I had told Judge Reeder, that if the court does grant the severance and the C3 is going to be appointed, because it would have to be a C3 because of conflicts with the other co-defendants on the cases that were severed, the co-defendants, which I believe remained with Judge Farmer.
Just while we're talking about that, all the other defendants have been disposed of. Mr. Hinton was the only attorney the jail case.
No, talking about the ag assaults and the other charges in this indictment.
So I believe the only other case where he hasn't been indicted is the jail, larger jail case.
Okay.
And those have all been disposed of. So Mr. Hinton remains the only one remaining.
And just so I'm clear, when you say the jail case, there was a May 20th, 2017 aggravated assault on a Deontay Knox, Knox. That's what we're calling the jail case.
So, Judge.
And that's distinct from the new jail case that does have 3 other defendants that I'll get. Mr. Head, Mr. Hill, and Mr. Jones.
That's right. This
Okay.
is originally what I've been referring to as the jail case 17 SC 153897 as originally indicted.
Okay. Can you also have your microphone on, please? Thanks.
Sorry, yes.
Great. Okay. I'm not going to worry about this brand new 21 SC case. I mean, someday it will need to be dealt with and it's coming here. Unless one of these other guys has an older case. But probably they don't.
That's how we wound up in front of Your Honor. This was originally a Judge Schwall case. And then because one of the other co-defendants had an older case, we went to Judge Campbell, who then, of course, retired and went to Judge Reeder, to Farmer, back to Judge Reeder, and then to you.
Yeah, it's a little richer than that. I effectively got it transferred to Judge Reeder and I inherited Judge Reeder's caseload. So I gave it to myself.
What a wonderful present.
Yep.
So in terms of the sequence, Your Honor, that I believe that's basically an overview without getting to the merits of the motion.
Sure.
To sever and the request to quash the no pros.
But more to the point of where are we heading, your objective is to try to resolve this short of trial if you are able to obtain through Ms. Convery an offer that you think and Mr. Hinton thinks is reasonable in light of all these charges.
Yes, Your Honor.
Okay. And so the record's clear. It's actually Mr. Pinion, not Pinson, but that's okay. You didn't get to spend a lot of time with him. You and Mr. Pinion were starting that conversation You hope to have it pick up some steam when the new district attorney began her tenure, but then Mr. Pinion was reassigned. And we've got someone who has committed to me, Ms. Convery, that she will keep this case until it is resolved, whatever resolution might be. So the two of you, I guess, will continue those discussions.
Yes, Your Honor.
Okay, great. Ms. Convery, anything you want to add? Not so much about the distant past of the case, which it was very helpful to get this update. And I've been learning more as I try to navigate Odyssey and all the links between old indictments and newer indictments. But anything you want to share about where we are and moving forward?
No, I don't think so. I think the recitation that the court's already received is accurate, and I don't take issue with any of the things that have been outlined. And I did the same as the court and went back and navigated the previous transcripts and sort of all the previous cases that were originally indicted separately, how we got here. So I don't have anything additional. When it's appropriate, I do not anticipate calling Sergeant Young. I have him sort of here in the abundance of caution because I was a little bit unclear as to any potential substantive evidentiary motion based on counsel's response to the court's order and just my review of the record. So I sort of have him here in the abundance of caution. It's the state's position based on my review of the entirety of the case file and all the previous pleadings in this case that there's no evidentiary motion outstanding. So when it's appropriate, we can address that, but I'm going to let him free as soon as we're all on the same page.
Great, and we'll get there shortly. I want to talk about discovery first.
Sure.
Yes, ma'am.
I'm sorry for interrupting the court. When Karen and I spoke yesterday, we had that discussion. It was about 3:30 in the afternoon. The defense's position is the same now as it was back in September of 25th of 2019, that there are 3 evidentiary motions.
Well, and we'll talk about that. I want to talk about discovery first, and then we'll get to that. So what I remember from the teleconference that Ms. Young and Mr. Pinion and I had was that Ms. Young, for a while, months, had been asking and then ultimately clamoring for criminal histories for a number of potential state witnesses. I saw that there was supplemental discovery served on the 3rd and the 10th of this month. One of the discovery packets was criminal histories, a bunch of them. And then the other, I didn't follow quite as much just because it probably used terminology that meant more to the parties. There was some phone extractions and some photos and something that says Bynum, BYNUMIG. I don't know what it is. I don't need to know what it is. It was a bunch of stuff that was provided to Ms. Young. And I'd like to hear from you, Ms. Young, if you feel that you now have what you've been asking for, or if there's more we need to talk about concerning discovery. You clearly got more than you asked for because you got some criminal histories, but then there are all these other things that maybe another prosecutor thought you had received. I'm hoping that the phone extractions weren't something that just happened in the last week, but I need to hear from you as to where you think you are with discovery.
Thank you, Your Honor. Karen and I spoke, Ms. Convery?
Yeah.
Yes.
Thank you. Ms. Convery and I had communication by email regarding the NCICs. I forwarded to her attention emails between Mr. Pinion and myself confirming that the court had in fact ordered these. And she notified me that they would be available, I believe a week ago, Tuesday.
It was on the 1st of the month.
Okay.
Okay.
Whenever, I don't know what day I'm in.
I was in Arizona doing work for a client and I was planning on picking them up when I returned. But the DA's office beat me to it and I appreciate that. It got to the office yesterday after I left.
Okay.
So I'll be going by to pick up the NCICs and the other discovery. When I spoke with Ms. Convery yesterday, she had, as a proffer, indicated that the extractions were new, that they were enhanced from what was previously served, but if there are any discovery issues, I don't anticipate having a problem speaking with Ms. Convery and catching up to speed and then apprising the court.
Okay, well, I'm particularly focused on the criminal histories because that's what you had put forth as an outstanding matter. And we did go back and forth, and I think in front of Judge Reeder, there was some back and forth when it was Ms. Love who was the prosecutor, that there are in fact ways for private citizens, defense attorneys, et cetera, to get these things. And we all agreed that it's easier for the state to get them, but it doesn't mean that the state has exclusive control over them. But it sounds like we've pushed past that, and Ms. Convery has obtained what she can obtain and has provided that to you. So if you would make that your priority as to what you look at, so that you could let Ms. Convery and Ms. Nelson, my litigation manager, know if you feel like there's anything missing there. This additional supplemental discovery you got, it may be good news for you because it's exculpatory. It may be not so good news for Mr. Hinton because it's something else that connects him to one or more of the charges here. But those I'm less concerned about. That's the state continuing to comply with its discovery obligations.
Thank you, Your Honor. I did, after the September 25th, 19 court date, I did go back to GBI and sent an email, and there's a printout in the box somewhere, asking, have I misunderstood? I know I can get GCICs, but can I get NCICs? I had already tried to speak and communicated with the FBI, and then called somebody I know in Secret Service to say, look, am I just missing something? And the answer was unilaterally no. I would need teletype access to get NCICs. Those are not available. The GCICs are available, but I'd already gone through that, and we'll go through another round of requesting updates.
Okay. Well, what I'm recalling Mr. Pinion observing was that the folks we're dealing with here would be highly unlikely to have something on an NCIC that's not on their GCIC, given age and origin, whatnot. But it doesn't mean you're not entitled to it. And it sounds like Ms. Convery has done her best to get you what you need. So I'm going to assume all is well, unless I hear back soon that all is not well with the criminal histories. Ms. Convery, do you have anything else brewing on the discovery front that you can't hand over yet because GBI is doing it, or APD is working on an electronic device that in the past either the technology didn't exist or a less thorough prosecutor didn't think to do something with it?
Nope. I think what the court has just outlined is what I've previously served just recently to Ms. Young, and I was able to get the renewed warrant and go back through a different software essentially for those phone dumps. Another one of the phone dumps that the court will see on the certificate and that Ms. Young now has is the extraction from the device seized at the jail. So that's for the new 21 SC case. I went ahead and served her a copy of that particular phone as well as the report from the jail. So some of that discovery is just, I went ahead and gave her, even though I'm not sure that will be hers, but just because I was looking at it and had it, I went ahead and served that. So
sure. And it might be something you would choose to use
right.
Should there be a trial in the 18 SC case.
Right. But nothing else on the state's radar, of course. Should something arise, my first thing I'll do is serve it.
Excuse me, Judge.
Yeah, it's a copy of the warrant that's the warrant for his tattoo photos. I served that as well.
Okay.
Yeah.
Thank you. Sorry, Your Honor. Not to speak to counsel without involving the court. My client handed me a copy of the search warrant that's dated June 8th of this year. So I didn't know if counsel was aware that this had been done yet, and if that was included in what was in the envelope, and she's indicated yes.
Yeah.
That would be the tattoo photos, Avante Hinton search warrant.
Yes.
Yep. So you should have a less crumpled version of that in what you'll be picking up today from your office.
Yes, sir. Thank you.
Great. All right. Discovery and criminal histories, check. The motion to suppress, and I may need to push it more broadly than that. I was able to find in mining the various dockets for Mr. Hinton's many older indictments, one motion that, if further particularized, might require an evidentiary hearing. But you've said, Ms. Young, that there are 3 that require evidentiary hearings. So the one I was able to find was a motion that you filed in January of 2017 in the case 16 SC 147091, which, if I look at Ms. Convery's handy dandy decoder chart, that was part of her motion, her response, motion to sever. It was originally the murder case. So what I'll call the standalone murder indictment. In that case, Ms. Young, you filed a motion on January 4th, 2017, entitled Particularized Defense Motion to Suppress and or Dismiss. This is different from your Jackson-Deno. The Jackson-Deno has been litigated. That's done. And a higher court has said that's the law of the case. The one I'm referring to, you alleged 4 things. One was that the police lacked probable cause to arrest Mr. Hinton. And so anything recovered as a result of his arrest was illegal and should be suppressed. I guess that would be an evidentiary hearing, now that I say it out loud. The one that jumped out at me, though, was number 2. And you say there was an identification procedure, and you described that as being unlawfully suspect and biased, and should be suppressed. You use some other negative adjectives as well, but you say it should be suppressed. And then your other 2, I don't think require evidentiary hearings. You're welcome to talk to me about them. But those 2, that there wasn't probable cause for the arrest, and so anything recovered from Mr. Hinton when he was arrested should be suppressed. And then this identification procedure. The only one that I flagged specifically for today was the ID procedure, if there was one. And I had asked you, Ms. Young, to further particularize it so that I would know, more importantly, Ms. Convery would know, oh, you're referring to that. That means I need Detective Young, now Sergeant Young, or I need Officer so-and-so. But your response to my scheduling order simply said that there was the use of an unlawful identification procedure. So I need you to tell me on the record what identification procedure you're talking about so that I can ask Ms. Convery, is that something you're going to use? Because if she's not, then it's moot. So I still don't know what you're talking about when you say an identification procedure. So let's start with that, and then we can talk a little bit about the probable cause for the arrest.
Thank you, Your Honor. And I apologize for not understanding the court's instruction. The identification procedure that I'm referring to is that, in terms of particularizing it, nobody saw my client shoot anybody, okay, as it pertains to the homicide case. Shots as a proffer, I believe the evidence would be that, even in the light most favorable to the state, that some neighbors heard shots, saw people running away, did not see their faces, and did not call 911 for 8 hours after that. And there's no forensics that tie my client to the scene of where the body was discovered the next day. The detectives and investigators then went back and started showing 1 photograph show-ups to people that already, according to their statements, had known my client for an extended period of time. It's the defense's position that that type of a show-up to people who are already familiar with the person that they're asking about. It's like if somebody was to say, no disrespect, do you know the president? Yes, I know the president. I know what he looks like. I recognize him. I've not met him personally, although that's not the situation. In this case where the witnesses claim to actually know my client. That's not a proper, from the defense's position, not a proper identification procedure. Had they put instead of a show up, done a proper lineup, put it through APHIS, or use some other type of mechanism, whether it was photographs or jail photos, to put together a proper lineup. Who did you see? Again, we would, it would give at least the fairness of an identification rather than a show up, which I believe the courts have unilaterally kind of discouraged.
So you're using the term show up. When I hear the phrase show up, I think of purported eyewitness brought to the same place that suspect is. And so it's a physical, the suspect may not be able to see the eyewitness because the eyewitness is in a police car with tinted glass. But a show up to me is physically you bring the witness and the suspect into the same space so they can look at each other. Well, I'm hearing you use that term, but your description is that law enforcement had a photograph of Mr. Hinton and interacted with any number of witnesses to, I guess, ask either, is this Mr. Hinton or do you know this person?
Yes, sir.
Okay, so it was not a physical show up. They were not dragging Mr. Hinton from place to place or bringing these witnesses to where Mr. Hinton was. It was all single photograph based.
That's my recollection, Your Honor. And
Okay.
I apologize for the confusion. If the court would allow me to then refer to it as a one photograph identification procedure instead of a show up.
You can use any term you want. I just want to make sure I wasn't misunderstanding. Mr. Hinton was not physically present for any of these identifications that occurred.
Not to my knowledge. No.
Okay. What is your understanding of, in general, not verbatim, of course, the officers were asking when they were presenting the picture? Do you know this person? Is this, I don't know if they used maybe a nickname your client had, or if they said, is this Avante Hinton? And what was the nature of the exchange?
My recollection, Your Honor, is that the exchange had to do with alleged drug activities, alleged possession of a firearm within 24 to 48 hours prior to the shooting of the deceased, but not at the scene. Other times when they were asking about whether he had been at a different residence or a different location or at a location they believed to be a drug house. So it was all connected with their investigation as to who they believed was the shooter.
Okay. All right. So that's the identification procedure that concerns you, is law enforcement's use of a single photo in interacting with some number of witnesses, trying to learn more about what Mr. Hinton may have been up to.
Yes, Your Honor.
Okay. Got it. Are you aware of anything that, when you refer to the arrest that lacked probable cause and thus would be a reason to suppress, that lack would be a reason to suppress any evidence recovered from Mr. Hinton beyond his statement, which has been suppressed? Is there anything else you're aware of that was obtained from Mr. Hinton when he was, I'm assuming this is arrest in connection with the murder because you filed the motion in the murder case?
I believe that there were shoes purported to belong to Mr. Hinton that were obtained as a result of the statement, a direct result of the statement that Mr. Hinton made that's now suppressed.
So if it was fruits of the suppressed statement, there's a problem for the state.
Yes, sir.
But it's different from when Mr. Hinton was arrested for the murder. He was wearing bright green shoes and the state sees those. It would be, your concern is about shoes that were obtained, per your argument, as a result of the now suppressed statement.
Yes, Your Honor, they were not shoes he was wearing.
Okay. My question is, was there anything seized from Mr. Hinton when he was arrested that you're seeking to suppress?
Not that I recall.
So it's the shoes, which you believe in some respects are doubly tainted. If in fact there wasn't probable cause for the arrest, whatever flowed from that could be problematic. But in particular, you think it flowed from the statement that has been suppressed.
Yes, Your Honor.
Okay. So it's shoes.
Yes, sir.
Excellent. Thank you.
You're welcome. And to further clarify, Your Honor, as I recall, there were shoes that were at a location that Mr. Hinton was picked up at.
Okay.
So they were shoes that I believe they went back for based on the statement, which is now suppressed. So.
All right. If either of these motions goes forward, there might need to be some evidence taken. You said there were 3 evidentiary motions. That's 2. What would number 3 be?
Your Honor, does the court wish me to address item number 4 in the motion to suppress that we were just discussing?
If that would be the 3rd evidentiary motion, then we should talk about that. Otherwise, we'll come back to that.
Okay, thank you, Your Honor. In terms of the evidentiary motions, it was this motion that I believed were appropriate. Actually, it's 4, depending on what the state does on another issue. The first was this motion to suppress. The second was the motion to reveal the confidential informant, which require an in-camera hearing and testimony from the handler of the confidential informant to decide whether or not there is a danger to this person, go through those criteria, and then an in-camera view by the court to decide if it's going to be disclosed. The gang motion, a motion to suppress, not the demurrer portion of it, but the motion to suppress or dismiss as to gang affiliation, because from the defense's perspective, Your Honor, the gang motion or the gang charges in the case before the court, now the 18 case number, count 1, which is an unlawful participation allegations, number 2, unlawful gang allegations, and then some of the other counts. But specifically, the gang charges or charges alleging gang activity bootstrap the other charges in the case. So they're not alleging that my client in the indictment, they're not alleging that my client was involved in gang activity prior to these charges, which from the defense's perspective is necessary. So there would need to be testimony from the detective or from the officer or investigator that they believe they have evidence that my client was involved in gang activity prior to the indictment. That satisfy the statutory requirements of what is necessary for the court, depending on, of course, the court's view of the evidence, to come to the conclusion that it was not just a gathering, that it wasn't 3 people, meeting up someplace, that there's my recollection of the criteria basically is they have to show that he was in a gang, that it's a documented gang, that whatever actions were done specifically in furtherance of gang activity in order to come to the conclusion that, or to suggest to the court the conclusion that this was gang activity, not he just got sworn in, and I'm not, of course, making admissions, but that a person was sworn into a gang, went through initiation, and during the initiation, did things in furtherance of going to lunch, hanging out, nothing that furthers gang activity. So without the testimony of, usually it's a person who's well-versed in gang and initiation and.
But why does that have to happen before trial as opposed to that's the state's burden of proof? And so it would need to happen in trial. And if it didn't, rather than I don't know, that's a motion to suppress. It sounds like it's a motion to dismiss, which really we don't do on the criminal side. It would be a motion for directed verdict. And all these things that you said the state needs to do, if in fact they needed to do them to prove up counts 1, 2, and 3, all of which are gang-related counts. If they had failed to do so, then no longer before the jury would be any of the gang counts. Is that not the right mechanism to address your concern?
I think I understand the court's question. Whenever I'm involved in allegations of gang activity and defending a client, I request, and it doesn't happen that often, I don't do a lot of gang cases, but I always request that there is a motion to suppress or dismiss if certain things haven't been specifically pled, specifically so that it doesn't encourage a mistrial. If the court was to rule, certainly it's the court's purview, that this is done in the state's case in chief, then I would be filing a motion in limine to preclude any mention in voir dire, in instructions, redact from the indictment until, and not have any testimony for the jury prior to them putting that predicate in, so that we don't have a mistrial and have to start all over again.
Right.
So it's for two reasons. One is to see, to advise the court from the defense's perspective that there is an indictment that's facially invalid, that there is a problem with the way it's charged. And also to see if the court would entertain this motion prior to picking a jury, so that if we do get to the point where we're in front of a jury, I'm not objecting to every single question, letting the jury think, oh, I'm being one of those defense attorneys and obstructionistic, that I can just object to based on a prior ruling if the court allows it. And then if the court and the evidence flows smoothly, rather than going through questioning the officers to background, education, criteria, and all the different things that would come out in trial, and then having to go back and we can't go back to voir dire, so the jury's not been questioned about anything that's gang related. Their perceptions have not been tampered with or clouded by allegations that there is gang activity, and then they hear no testimony, or they do, and then it's suppressed, and then they're looking at my client like, what has he gotten away with?
So which motion of yours or motions set forth the law, or at least the claim that you're raising that there ought to be a pretrial hearing, a sort of threshold finding that it's appropriate for the first three counts to?
And I believe in my binder, I have a motions binder, Judge, sorry. It would be the motions to quash or dismiss and or general and special demurrers to the indictment. And I filed them, one in general that was e-filed.
I know what those two motions are.
Oh, okay.
We're going to talk about those today. So,
okay. And then the second, the one that further specifies counts 1, 3, and 6, alleging gang activity, and cites to on page 2 of my motion, Your Honor, if I might, the second paragraph of item 2 on page 2, that without going through all the language, the case of AD, a child, and the interest of JW, a child, with cites where the Court of Appeals in Georgia states that, if I can quote, as I have in my motion, the underlying crime committed cannot, in this case, cannot serve as proof of the necessary gang activity. And they cite to the Georgia Supreme Court's decision of Rodriguez versus State, which is also cited, and quotes, the commission of an enumerated offense by the defendant is not itself sufficient to prove the existence of a criminal street gang. If it were sufficient, the nonsensical result would be that a member of any legitimate group could violate the act. So that would be one portion.
okay. Well, I know what motions you're referring to, and we'll talk about them today. And if we need to set them down for a specific evidentiary hearing, we can do that.
Thank you, Judge.
All right. Let me hear from Ms. Convery on the first three that Ms. Young and I discussed: the identification procedure, the shoes, and the CI. Because you were mentioning that you weren't sure we would need to have evidentiary hearings. And that might be because either you're not using that evidence, or it's really a legal issue. If everyone agrees that the police were going around with a single photo of Mr. Hinton, but it was in the following context, and it's stipulated to what that context is, I can decide whether that is a suppressible event or not. But we've got Sergeant Young here, and so if he was one of the people walking around with the photo of Mr. Hinton. He can talk about that.
So I'll start with the single photo ID issue. And I guess the state wanted to be prepared for today, which is why I was scouring because there's multiple individuals. Just a quick list. There's approximately 5 or 6 probably witnesses. And when I say witnesses, the state's position is that these individuals are associates of the defendant. They're not witnesses to the actual scene itself, with the exception of one individual who's really a kind of a secondary suspect. But the context of and I've been able to listen to all the interviews now that Detective Young did in this case, and almost every single time, without exception, now that I'm kind of cataloging all the interviews, the single photo, the display of the single photo, and the conversation that goes with that is essentially, hey, am I talking about Lil Bruh? Like, are we on the same page? Is this who I'm talking about? Every single individual that looks at a single photo of Mr. Hinton is able to quickly confirm an ID that, yes, we're having a conversation about the same person.
And the conversation is one in which the person being interviewed has indicated that he or she knows Lil Bro or Hinton, by whatever name they're referring to,
right,
our defendant. And it's a confirmatory display of the photo, as opposed to, is this the murderer? And it's a complete stranger saying, oh, yes, I think that's the person I saw in the dim lighting waving a gun on the street.
Yeah, exactly. Exactly the context that the court just outlined, that it's confirming, hey, we're about to talk about the same person. Are these the people that you hang out with? Are these the people that may be at X, Y, and Z location? But none of the witnesses who looked at a single photo are fact witnesses to the actual homicide itself or the immediate circumstances surrounding that.
Are you aware of any instance in which any member of law enforcement, in interviewing someone who did not already indicate, I know Mr. Hinton by whatever name, said, does this look like the killer, or anything that would be what the law would view as an eyewitness identification, as opposed to, as I think it referred to it, more of a confirmatory identification? Sounds like the setting that we've got here.
No, Judge. All of the single photo instances that the state is aware of are confirmatory in nature.
What about property seized from Mr. Hinton following his arrest in the murder case?
I want to just quickly note too, so in case we have a secondary thing, it doesn't come up, there is a 6-pack or a photo array shown to what would have been a fact witness to the murder. It's one of the eyewitnesses that Ms. Young mentioned, who actually hears the shooting, sees people running away. Detective Young and another detective from Atlanta made and showed him that lineup, and he was not able to make a selection. So I don't think that's
nothing to suppress there.
Right.
Okay.
So on to the shoes. The state is not aware of any physical evidence that I'll be able to, or certainly that I would intend to introduce related to the shoes, but that is something I could quickly clear up with this witness. The circumstances of Mr. Hinton's initial arrest were based around a search warrant of a particular house, a place of business, a trap house, essentially. He's taken into custody. He's certainly interviewed about the homicide after being taken into custody there.
Would that be why we'll get into this later? You don't have to go real deep into it, but one of the sets of charges that was a separate indictment, I guess it's the 16 SC 147090. That indictment charged Mr. Hinton with possessing heroin and cocaine with the intent to distribute.
Yeah, and on the cheat sheet, is that date subsequent to the homicide?
Yeah, June 10th. So it's a little less than 2 weeks after the killing of Mr. Bernstein, Burnstine.
That's right. That's why that's the arrest of Mr. Hinton and the subsequent warrant surrounding that is what gave rise to those charges.
Got it. So June 10th of 2016 is the execution of the warrant at what is believed by police to be a drug house. Mr. Hinton is scooped up as a result of the execution of that warrant. Interviewed. That interview has been suppressed. Maybe a pair of shoes were seized. You can confer with Young, meaning Sergeant Young, in a minute, but you're not aware Ms. Convery, of any physical evidence seized as a result of Mr. Hinton's arrest on June 10th of 2016. I mean, there may have been all sorts of things seized in that house, drugs, et cetera. That's not in front of me right now. What I'm hearing Ms. Young, Attorney Young, saying is that there's this pair of shoes that they got only after they interviewed Mr. Hinton, and those shouldn't come in. Those shoes aren't jumping top of mind to you, but you can talk with Sergeant Young about that.
That's a 2-minute for me to confirm.
Okay.
The judge, I need to correct something that I said. I just spoke with my client, and there's also a phone
A phone.
that was taken from the house. They went back to the house as a result of the statement, and I believe I remembered the shoes. I had not remembered the phone.
Well, we'll need to explore that with Sergeant Young, and people may need to look at paperwork. I don't know why, if they searched the house, they would have left a phone there. Shoes doesn't surprise me, that if they've got a drug search warrant, they don't seize shoes. It would be peculiar unless the phone was in a really, really hard to find place that they'd leave a phone behind.
Okay, and Your Honor, I'm certainly not making any admissions. I just asked my client, had a conversation with my client. I may have.
You're not admitting anything. We're trying to make sure that if we need an evidentiary hearing, we have it. And if we don't, we don't.
Thank you, Your Honor.
And so from the state's perspective and my review of the statement, again, I'm happy to inquire with Sergeant Young, but the arrest is made. Certainly there are other things going on with the arrest, and other charges came about, the drug charges, but there was a search done incident to that. I don't believe that there was a secondary search party that went out to the house as a result of the content of the interview statement. That's a 2-second inquiry. As far as the phone is concerned, I'm much more confident that the phone is initially seized by officers who are responsible for the arrest and search at the house on the 10th. Subsequently, the detective and now Sergeant Young applied for a search warrant on that device, and there was an extraction done. So that's not as the result of the content of the now suppressed statement. From the state's perspective, at least.
All right. What about the CI? I feel like, I don't remember, but I feel like this came up with Mr. Pinion, and he said something to the effect that led me to think we don't need to worry about that anymore. Either the state's not going to use it or who knows what. That doesn't necessarily close the issue out, but Ms. Young has brought it up again. There is a motion to reveal the CI in at least one of these cases rattling around. Where are we with that?
So I did not see that particularized anywhere. I was able to review the 85-page transcript for the previous suppression / Jackson Deno / status with Judge Reeder, and the date. We've been talking about it a bunch, but for the purposes of the record, that the transcript I've been reviewing is from the hearing that occurred on September 25th, 2019. The
Judge Reeder hearing that resulted in the suppression of the statement.
Right. And it looks like they're sort of cataloging the issues outstanding. And and again, I've just been through it maybe twice. I believe that it was sort of offered to the court that was sort of a non-issue. Sounds like that might not be correct anyway. If this court has heard specifics on the confidential informant.
I don't remember enough other than that I feel like it came up when Mr. Pinion and Ms. Young and I were talking about it. So it may be we need to find the motion, and then we can talk about it a little bit more. I'd just like us to get a perspective on it while I've got everyone here. What would given the way this has played out, I'm wondering if the CI is someone who was involved in buying drugs from this house, and that was the basis for the warrant to get into the house, as opposed to a CI who said, I know something about the murder.
It's certainly not a confidential informant related to the homicide investigation.
Okay. So it's already ancillary. It's not someone who said, I can tell you who the shooter was.
No.
Okay.
And it's my best understanding of any CIs implicated are for one of the previous drug cases that were joined in this indictment.
So there is a motion in the original murder case, the indictment ending in 091, that was filed on January 4th, 2017 by Ms. Young. And so all it says is the informer is a material witness on the issue of defendant's guilt or innocence. And this informer was present at a time relevant to the defense. So I guess today is a great day for Ms. Young to get more specific on that so that we can figure out if such a person really exists.
Thank you, Your Honor. Ordinarily, in my experience, and I know the court has much more experience, sees a lot more, Ms. Convery may also, usually a confidential informant is somebody that is obtained or groomed through law enforcement. They have.
So let me pause you for a sec. We can talk a lot about CIs if we need to. What leads you to believe there was a CI that assisted law enforcement in any way in connection with the murder case?
Thank you, Your Honor. If the court looks to the motion to compel that was filed on the 16 SC 147091, on page 2 of that motion, item number 5, whenever there is an unknown person which is referenced by law enforcement and used during the course of their investigation, I put it into, as a matter of practice, a motion to reveal a confidential informant because there's no other mechanism to get it before the court. So do you have this, Ms. Convery? It's a January 4th. It's the same day the reveal of the CI was filed, and paragraph 5 is asking for information about someone named Red, someone named Javon, Jamaica, Jameka, an unknown man with a camera, an anonymous caller, which is going to be tricky to disclose if it was an anonymous caller, 2 unknown witnesses, and then a confidential informer, critically, on the heroin arrest, not the murder. But helpfully, all of these folks are further identified by Bates numbers so that the state can figure out where in the record these people are referenced. And the Bates number refers to a number that the district attorney's office put on discovery they provided to you, Ms. Young. yes, Your Honor, the initial discovery that was served on the 16 SC 147091 was Bates stamped.
Great. Okay.
And in terms of the anonymous caller who spoke with the police department, very often there's a record, even though they classify the person as anonymous, they have a recording that says the call came from, and they list the number, although they classify them for investigative purposes as anonymous. Could be in the detectives or the officer who spoke with the caller within their notes, which would not then be given to the defense in discovery, but they would be retaining.
Got it.
So
this was
want the court to think that it was just some,
No, I didn't think you made it up. I just needed to know where you saw it. So your entry number 5 in this motion to compel relates to a number of folks who are not confidential. There may be more info about them, there may not, but there was, according to discovery you received from the state, a confidential informant in connection with, it says the heroin arrest. I assume that means the search warrant and whatever empowered the police to do what they did on June 10th, 2016. So you may need a little while, Ms. Convery, to look up those Bates numbers, and you may have some pushback to say, I can see why you think there was a CI, but there wasn't a CI.
So I'll briefly let the court know. I'm familiar with all of the names referenced in the sort of the first series of Bates stamp numbers. Red, Javon, Jamaica, unknown man with camera with chip. I'd have to double check that one. But as far as in the sort of traditional legal terminology, I guess, for confidential informant, state's position remains the same about there not being one used in this case and employed in this case for the homicide investigation. I will need to look more specifically at the heroin arrest reference.
Because that is part of the 18 SC indictment. If the state prevails on the severance debate, even partially, and it could be that what would go to trial in phase one would be the murder charges and the drug charges. They are very close in time, and you may be able to articulate how they are related in terms of motive or other matters. Then if there was a confidential informant in connection with the police activity at the drug house, I would need to work through whether that person needs to be disclosed.
Sure, and I just need to look at bait stamps 9 through 11 to be sure. There are a couple heroin incidents that have been joined into this indictment, so I need to be sure whether it's the June 10th, the subsequent arrest post homicide, or one of the previous incidents. But again, that's a couple minute inquiry.
Sure. My understanding of the other heroin incident, which was a March 30th, 2016, it's now count 11, it was a separate indictment, was that Mr. Hinton sold to an undercover officer.
Right.
So that's not a CI issue. That person is or was a police officer. Okay.
I wonder if I might, certainly if Ms. Convery learns that there is no confidential informant and is, willing to provide an email to me, then
It's moot.
It
Right.
is, and then any other unknown person, again, similarly, if it turns out that that these people are not going to be used or their information is not going to be used, then that would end, of course, the defense's objection.
Sure. And there's the middle ground in that the confidential informer could be someone who made a controlled purchase from the house 2 days before the warrant was signed. But if that person doesn't say, and I purchased from Mr. Hinton or Lil Boy, just that I went there and I used state issued funds and bought heroin, typically those folks aren't so disclosable because if they don't have anything about your client, then that's usually less of an issue. We need to understand what role the CI played, if there was a CI in connection with the June 2016 search warrant. And I assume that's not Sergeant Young.
No.
Okay. I mean, not that he's not the CI, but his connection to what we're working through today is the homicide. And it was a coincidence, may be the wrong word, but the search warrant executed on June 10th wasn't issued with the expectation that they would find the suspected killer of Mr. Bernstein. Is that a fair statement or that's incorrect?
I think I'll ask because I don't want to.
It doesn't matter. I just.
Not there, but I think they were aware. Detective Young, in his capacity as the lead detective, was certainly aware of Mr. Hinton, was interested in speaking with him related to the homicide. I think that area in particular was pretty active with the Apex and suppression team units. So they may have worked together about maybe something that was already ongoing in that location, but he knew that should there be arrest that day, he did want to talk to him.
So it's possible, and this doesn't, we don't need to sort this out today, but it's possible that Young was hopeful that the execution of this, whether it was Apex or the narcotics unit search warrant at whatever address it was, might allow Young to catch up with Mr. Hinton, because by June 10th of 2016, Detective Young was looking for Mr. Hinton in connection with the killing of Mr. Bernstein.
Yes.
Okay. That helps me understand. So that's a different posture than, oh, what a coincidence. There was this search warrant executed, and when everyone was arrested at the scene, there was a hit on, meaning the system indicated there is a separate warrant for Mr. Hinton, and left hand and right hand didn't know that, and it was just a happy coincidence for the police. Okay. And what about the gang counts? I think of the three of us, Ms. Young, myself, and you, Ms. Convery, you spend the most time dealing with gang allegations. Like Ms. Young, I certainly wouldn't want to start a trial, only have to redo it because we weren't thoughtful about the way in which the gang allegations were handled. I know that gang allegations are a target-rich environment for successful appeals. if they aren't handled well, because they are understandably prejudicial, especially right now in Atlanta. But that doesn't mean they're inappropriate or can't be used. So I want to make sure we go through the right gatekeeping so that if it's appropriate to include them in the charges that go to trial, we handle voir dire correctly, and you can say what you ought to be able to say in your opening if they're going to be in there. So if there are threshold findings that you think it is safer for me to make, so that we don't get to a motion for directed verdict, if granted, then is followed by a request for a mistrial, because you can't unring that bell of Hinton gang. Oh, but ladies and gentlemen, don't worry about the gang thing anymore. That genie doesn't go back in the bottle.
Right. So when I inherited this case file, I paid special attention to that just because I wasn't the DA to indict this case. So I took a pretty thoughtful look at the sort of totality of everything we had on that issue. Some of the things that the court saw recently served are just things in my practice that I didn't see in the file that I would want if this advances to trial. I feel confident that it is appropriately charged. I think a lot of the courts sort of, not concerns isn't the right word, but what you'd like to maybe hear me talk a little bit about more, we'll address in the severance issue. And then as well as the demurrer, certainly, I don't know that the demurrer issue and whether or not it's pled correctly gets to the whole issue, but I think I'll address it enough and more completely so that the court would feel comfortable. Should we advance with those on the indictment? The state's position is it again appropriately is there on the indictment now and is charged correctly as is. As far as sort of steps before we get there, I'm happy to address it with the court because the state shares the same concerns. I don't want to try this case again either. It's got some significant age on it, but the issues brought up by defense counsel, I think, are trial issues. I think they sound like things that would be raised at a directed verdict motion or hearing, and I don't know that they are things that are appropriate to be sort of addressed right now, but I am going to address the issue of sort of the state's theory around the gang nexus in this case and the connection to the rest of the charges in the severance motion as well as in the demurrer.
Okay. Why don't we pause for a couple minutes so that you can check with Sergeant Young about what was seized as a result of Mr. Hinton's arrest on June 10th. And if we need to get something from him under oath on the record, we can do that. But if the state is going to represent phone was seized when Mr. Hinton was arrested and not after his statement, then I don't think we have an issue at this point that needs to be litigated. There could be a big problem for the state if all the testimony at trial shows, oops, that wasn't right. But I suspect that Ms. Convery would make extra sure that the chronology of events would be arrest, seizure of phone, maybe of shoes as well. We'll figure all that out. Statement is suppressed, statement can't be used, but there wasn't anything that flowed from it. And that's really, I think, the test here is what, if anything, did law enforcement acquire as the fruit of the now suppressed interview with Mr. Hinton? And if the answer is only the information he told us about, then the remedy has already been issued by Judge Reeder. But if the answer is, oh, then we went back to the house because we learned that underneath the garage in a hidden compartment would be a phone and this pair of Nikes, then those need to not come in. So why don't you check with him and we'll be at ease for a couple minutes.
Thank you, Judge. May I use the restroom?
You may. Oh, how did you know that was down there? Or did you stash it there? Oh, okay. I think that's a big bag. It's Halloween.
So we did a Father's Day thing for all the males this morning.
Oh, well, that's good.
So we did like these little cards. Stuff with snacks.
Judge, you have anybody else on the calendar that's supposed to be walking in?
No, the only two folks we have today are Mr. Hinton this morning and then Mr. Allen, who was brought in from state custody this afternoon. Okay?
I don't know what to do. I was too bad. He was there until I went to.
Okay. Do you have a case number or anything? Why did you think you were supposed to come to court today?
Pre-trial, so
Who told you?
pre-trial.
Okay. Let me see if I can find you in the system. How do you spell your last name?
MCCARVER, B is the bad.
McCarver.
Yes, sir.
First name James.
Yes, sir.
James McCarver. All right, let's see. Here you are. There's not a entry in the docket. Let me make sure we've got the right guy. Looks about the same. You weren't wearing glasses back then, but that's all right. I want you to be able to see. You live in Snellville?
Yes, sir.
Okay, so we got the right guy. Yep. So your last court date was in December of last year. Your final plea date. The case didn't work out then. And you are on a trial calendar for the latter part of August. So I will tell you, you have a new lawyer now, Miss Snyder, who'd been working with you. She left the conflict defender's office. Yeah, so you will not reach her because she's not there anymore. Her supervisor, Ms. Bernard, has taken over. I don't have a direct line for her, but you should be able to call. Let me see if I can get your phone number for the general conflict defender's office. Oh, it just showed up. I'll write it down for you. Sure. All right, so this phone number is the phone number for Ms. Bernard. I put her name on it, and she is taking over Ms. Snyder's cases for now. So you should give her a call, let her know you came to court today. Not sure why pretrial told you to come to court today, because your next thing is not until mid-August, okay? All right, take care of yourself. Oh, look at that, a car. That's hilarious. And inside is all this loot. Oh, it's from Captain Cabinet. This is for the captain, or? Oh, so each person had their own? Really? That's amazing.
Like 4 years ago.
That's impressive.
Judge, as a housekeeping matter, do we need to put on record why the other attorney who was on the case as part of the defense is no longer?
I don't think so, unless you want. You're welcome to put on the record what you want to put on the record. No? Okay. You're the attorney of record. That's what matters, and you're here.
Yes, Your Honor. I don't know whether he ever filed a motion to withdraw prior to passing. And so
Mr. Gavrin's name doesn't pop up when I look at Mr. Hinton's case. Yours does, so that's the important part. I mean, you'd be free to file something if you want in connection with that, but I don't think it's necessary.
okay, thank you, Judge.
Sure. Ms. Convery, did you have an opportunity to speak with Sergeant Young
I did, yes.
and share with us your understanding about whether there was anything seized in connection with this case against Mr. Hinton subsequent to his interview with the police following his arrest in June of 2016?
Okay, there was not. This detective, now Sergeant Young, was with the narcotics team when they executed the warrant on the house.
Okay.
So as I suspected, and he confirmed, they were sort of working together. It certainly was a narcotics warrant. And I'll talk about the confidential informant issue in the context of that warrant, because I think that might apply there. But Detective Young actually went out with them, was present when they hit the warrant, for lack of a better word there. The defendant actually flees the scene of the location without
Hence the
shoes.
obstruction charge.
Yeah, without shoes. When narcotics goes through the house, does the search of the house, Detective Olson from narcotics takes 2 cell phones that are associated with the defendant. Those are signed over to Detective Young while they're still physically out there on the scene. It's actually Detective Young that transports Mr. Hinton down to the homicide headquarters, and they go back into the house before they even make it to homicide headquarters to get him shoes because he's barefoot. That's it, essentially.
Okay, so there is a pair of shoes and there are 2 phones, but your understanding of what the evidence is and that the trial testimony would be is that the phones are seized as a part of the search. And in fact, they're given to Detective Young before he leaves the scene, and he leaves the scene with Mr. Hinton. So he cannot have obtained the phones after the statement because the statement is down at police headquarters.
Correct.
And similarly with the shoes traveled with Mr. Hinton, so he did not go to headquarters barefoot or sock-footed. But there was a delay between arresting Mr. Hinton and getting the shoes because he was arrested with no shoes.
Correct.
Okay, I think I understand that. I think based on that representation, Ms. Young, I would say that that motion to suppress the property is moot. Not that it's denied, but that I guess it could be denied, but it sounds like the chronology, as you were led to understand it just by chatting with your client, isn't reflected in what the testimony would be from the state. So I'll handle this however you want to. We've got a sergeant here, and if we want to make a record of that, I'm happy to do that. We could do the same with the ID procedure, but neither one of those motions sounds like, based on Ms. Convery's proffer, that they'll be particularly fruitful for the defense. But I'm happy, since we have Sergeant Young here, to let you ask him whatever questions you want about that.
Judge, if Ms. Convery and I could go back and ask the sergeant, that might make things a little faster than actually taking testimony.
Sure.
Are you okay with that?
Sure, of course. And I'll just, for what it's worth, I'm very familiar with the court's ruling as well as the Supreme Court's ruling about the statement. And so I will make sure that nothing elicited from of course, that'll be my problem and burden at the trial, but I don't intend to elicit anything that came about as a result of the now suppressed statement.
Okay, and I didn't hear that. I mean, these motions were filed before that good news arrived for Ms. Young and Mr. Hinton, so they're not connected in that way. But certainly that would need to guide the way you examine Sergeant Young, for example, that he'd need to stay away from anything Mr. Hinton said in that interview. Why don't you all take a moment to talk with Sergeant Young, and then come back on out here and we'll figure out what we'll do next. Sure. Mr. Hinton, do you need to use the restroom or are you good?
Let's say.
Okay. Mrs. Young, did you have a chance to speak with Sergeant Young, who's not related to you?
Yes, Your Honor. I did, and I was hoping that his testimony would not be necessary, but based on what he said to me in the back, with Ms. Convery being present, we do need his testimony on record.
Okay, we'll do that before we bring Sergeant Young out here so he can testify and be on his way. Was there anything, Ms. Convery, you wanted to add about the confidential informant request?
No, I would,
Because
go ahead.
I thought somehow that you were going to talk to Sergeant Young about that as well.
I did,
Okay.
and I asked him if there was specifically about the confidential informant in the context of the drug investigation, and I believe that I need to take a look at the warrant itself that narcotics did on the 10th, but I believe that issue would be relevant for that warrant issue specifically, but my position is the same on any CI as it pertains to the homicide specifically.
Okay, but I appreciate that, and maybe the CI motion was filed in the homicide case, but we don't have just a homicide case anymore. And so I've pulled in all the motions that I could find that were still pending across the several cases to make sure we resolve them. So if what's going to trial is, as I mentioned, homicide plus drug house, then the CI may be relevant, or at least we need to work through the concerns that Ms. Young raised. It may not be through this witness because the CI would have been a narcotics CI as opposed to a homicide CI.
Yes.
Okay.
That's fair.
All right. Well, let's get Sergeant Young out here and you can ask him the questions you want to, Ms. Convery, about the shoes and the phone. And the identification procedure, and then Ms. Young will have a chance.
So also address the identification.
Well, I wasn't sure. From what I heard, I felt like the proffer was sufficient for me to rule. The only six-pack shown resulted in a non-identification, so I suspect that's not what Ms. Young is interested in suppressing. I heard her concern to be there was someone walking around with a single photo, but the context of all of those, as represented by you, Ms. Convery, is they were confirmatory identifications of people who had already said, here's someone I deal with on a regular basis. My words, not yours. And the detective simply said, is this the person we're talking about? And my understanding of the case law is that's not a problem. So if we want to get the sergeant to confirm that's the way in which he was using a single photo, we'll have a record that would support the ruling I intend to make, which is if that is what the evidence shows, then there's nothing to suppress. If someone surprises us by testifying, there was this eyewitness and I said, isn't this the killer? We've got a different issue, but I suspect someone would be jumping out of her chair before that question was answered and we could prevent the train wreck. Okay, sure.
We still have found that testimony we given to the number of proof at a declaring how to speak. The state is laying there the rough.
Michael Young, Y-O-U-G.
Can you band that down towards you? And there's a little indentation with a red light next to it. If you tap that, it should turn perfect, should turn green.
Michael Young, Y-O-U-N-G.
Sergeant Young, appreciate you being here. Ms. Convery is going to ask you a few questions, followed by Ms. Young, about two fairly discrete topics that have come up during the lawyer's discussion with me in Mr. Hinton's case about some identification work you may have done and about items that may have been seized in connection with a search warrant executed in June of 2016. Okay.
Sergeant Young, if you would explain to the court in May, at the very end of May of 2016, what was your role within the Atlanta Police Department as it pertains to the homicide investigation of Mr. Bernstein?
I was a lead detective for the homicide unit, and Kashan Bernstein was assigned to me on that date.
All right. And as a result of your assignment as the lead detective, did you have the opportunity to interview and come into contact with multiple people that you subsequently spoke with?
Yes, ma'am.
As a result of those, tell the court, did you have an opportunity to talk to individuals who knew the defendant, Mr. Hinton?
Yes, ma'am.
And just give the court a little bit of context around how it is that you came to speak to some of the individuals in the defendant's sort of immediate associate circle.
Some of the people I've met through canvassing around the crime scene. Some I was contacted via phone. Through my investigation, I talked to Kashan Bernstein's friends who pointed me in the direction of some of the people I interviewed.
Okay. And some of the people that you interviewed, did you talking specifically about the people who knew who Mr. Hinton was or were in his sort of immediate circle? Were any of those individuals eyewitnesses to the homicide itself?
Eyewitnesses, no, ma'am.
Okay. And for any of those individuals that I've been just sort of referencing generally, did you show a single photo of Mr. Hinton during your conversations with those people?
Yes, ma'am.
And tell the court in all of those instances, what generally was the purpose of showing that single photo? What was the context of that?
Just to know we're talking about the same person that might be involved in the homicide.
Okay. In any of those single photo identification pieces of those conversations, did anybody reveal to you, yes, that's Avante Hinton and it's the same person I saw shoot your victim?
Just that it was Avante Hinton, not that they saw him shoot him. Because this was a street murder, so a lot of times they use nicknames, like his nickname was Little Bro. So they referred to him as Little Bro. A lot of them didn't even know his real name.
Okay. Is it fair to say that the images that you showed or the purpose for showing all of the single photos in this case were essentially confirmatory in nature, making sure y'all were on the same page?
Yes, ma'am.
Are there any exceptions as far as people who knew Mr. Hinton? Every time that you showed a single photo, was that individual, that witness, someone who knew Mr. Hinton?
Yes, ma'am.
Okay. I think those are all the questions I have about the photo issue, and I'm going to just talk to you about a couple more. We spoke briefly before you testifying about the specifics of the June 10th search warrant and the eventual arrest of Mr. Hinton. Were you present on that scene?
Yes.
And tell the court just a little bit of background on how it was that you were actually physically present for the execution of the search warrant on June the 10th, 2016.
We previously received information when I was canvassing at the house. Still was selling drugs at the time. I contacted the narcotics unit, spoke with Detective Olson. I provided him that information, and he conducted his investigation, which subsequently he obtained a search warrant for the location. And I asked him to let me know when search warrant was going to be served, because I wanted to talk to individuals inside of the home. And he did, and I followed in the caravan on that day.
All right. And specifically as it pertains to Mr. Avante Hinton, was Mr. Hinton on your radar for the homicide specifically by the time that you arrived for the search warrant on June 10th?
Yes, ma'am.
And were you physically present when the search warrant was executed?
I was outside, but yes.
Okay. What happened? What happened when you were outside and the search warrant was executed?
While waiting on the perimeter, Mr. Hinton fled from the location and was apprehended a couple of blocks later.
Okay. And as a result of him fleeing from the location and you actually physically being there, did you subsequently come into contact with him?
Yes, they detained him. He ran into somebody's residence. They detained him. I met him at the location. I transported him back to the search warrant scene.
Okay. And what was the purpose of transporting him back to the search warrant scene?
He was, I think he was just he wasn't wearing a shirt or shoes. I transported him back to the scene to see what they may have found inside and also to get him some clothing.
Okay. And when you were back on the physical scene of the search warrant itself, did you receive any items from inside the house, or did you take any items from inside the house?
Yes, ma'am. Cell phone and shoes.
Okay. Who did you receive the cell phones from?
Detective Olson.
And was there anything done with the cell phones specifically after you received them from Detective Olson?
I submitted them to the the cyber crimes unit, which they try to extract phone data from it.
Okay. And was it you that applied for a search warrant of those devices?
Yes.
Okay.
So you left the scene of the search when you were done there with Mr. Hinton, and on his feet, he then had shoes, and you had as well whatever cell phones Detective Olson had given you.
Yes, sir.
And all that occurred before you interviewed Mr. Hinton down at police headquarters.
Yes, sir.
At any point after the interview, did you return back to the location for a subsequent search or ever seize anything else out of the house after you spoke to Mr. Hinton?
No, ma'am.
Okay. Those are all the questions I have, Judge.
Ms. Young.
Let's go back to the first set of questions regarding the photograph, okay?
Yes, ma'am.
Thank you. Can you hear me okay?
Yes, ma'am.
Okay. So when you were canvassing the crime scenes and talking to Bernstein's friends, you already testified that there were no eyewitnesses to his death, correct?
Yes, ma'am.
So you were attempting through your investigation and your training to connect or locate whoever you believed had shot Mr. Bernstein. Is that correct?
On the day of the shooting?
No, in general, through your investigation.
Yes, ma'am.
Okay. And part of your investigation was to canvass or speak to the neighbors, correct?
Yes, ma'am.
And part of your investigation was to speak to other people who may have known Mr. Bernstein or may have known Mr. Hinton, correct?
Yes, ma'am.
And Mr. Hinton was already a target of the investigation prior to you obtaining that photograph of him, correct?
Depends on what date you're talking about.
Just in general, during your investigation, you testified in direct that you had a single photograph of somebody that you knew as Avante Hinton, and also learned may have had the nickname of Little Bro. Is that correct?
I was just trying to determine who Little Bro was at that time. I received his photo actually from an undercover agent with the ATF.
Okay. And the photograph that you received from ATF of Little Bro, did it have the name Avante Hinton connected to it, either by writing or by communication with ATF or a database?
I believe that I got that through Officer Delane, which was, he was a local narcotics officer in the area, and he was able to give me his full name.
Okay. So prior to showing the photograph to any of the either eyewitnesses or neighbors or Mr. Bernstein's friends or friends that you believe to be Mr. Hinton's friends, you had already connected that the photograph you had was believed to be little bro, also believed to be Evante Hinton, correct?
The only person I showed a single photo to was his friends. I didn't show it to neighbors or any potential witnesses, that just friends to try to confirm that it was little bro Evante Hinton.
But I think the question is, the photo that you had, the one you used to show folks, you knew before you showed it to anyone that the person in the photo was Mr. Hinton.
Yes.
And you also knew, because of the assistance you got from Delaney and ATF and others, that Hinton equaled Lil Bro.
Yes.
So you may be talking with folks who knew Hinton as Lil Bro.
Mhm.
They're saying, well, Lil Bro kicks it here or there. And ultimately in the interview, you said, are we talking about the same person? Is this Lil Bro?
Yes.
My words, not yours, but I'm trying to understand the context.
That's what happened.
Okay.
Only to friends. I didn't show it to neighbors.
And the people that you are testifying were friends of Mr. Hinton were also witnesses to Mr. Hinton being at certain locations at certain times that was pertinent to your investigation.
Yes.
Okay. And that could include his opportunity to be near where Mr. Bernstein was killed, correct?
Potentially.
And also could be witnesses that said or that they had given Mr. Hinton a firearm within 24 to 48 hours of Mr. Bernstein being killed, correct?
Correct. They were friends for a long time.
Okay. And could have been witnesses that identified Mr. Hinton either with being involved at the trap house or with drug sales, correct?
Yes.
Okay. So the purpose of you showing a photograph of Mr. Hinton to people that you just testified had known him for a long time was really not to confirm who he was. It was to confirm that they were able to put my client, based on this photograph, at specific locations or in possession of certain items that you believe to be connected to the murder, correct?
No, it was to confirm we're talking about this little bro, Evante.
Was there another little bro that you were aware of?
I'm not sure, but it's the Bluff, and everybody goes by a nickname.
Okay. And when you say Bluff, just for the record, you're talking about a specific location called the Bluff.
Oh, that's correct. That area where the murder occurred was in the Bluff or near the Bluff.
Okay. When you were interviewing the witnesses and showing them the one photograph of Mr. Hinton, did anybody ever tell you during those conversations that there was another person named Little Bro?
Not that I recall.
Okay. And certainly that would have been in your reports, correct?
Yes, ma'am.
Okay. Judge, may I move on to the search warrant issue, or I don't know if Ms. Convery has any other follow-up questions?
I'll let her follow up when you're all done.
Thank you, Your Honor. In terms of the search warrant and the shoes, you had Mr. Hinton, who was already a target, correct, prior to the search warrant being obtained by Olson?
I'm sorry, he was a target of the search?
He was a target of your investigation, the homicide investigation?
Yes, ma'am.
Okay. And you worked in concert with Detective Olson to obtain the search warrant?
No, he did that investigation as far as whatever he does to obtain his probable cause.
Okay. Were you present when the affidavit and request for the warrant was presented to the magistrate or court?
No.
Olson notified you when they were going to serve the warrant, is that correct?
Yes, ma'am.
And did you have a chance to look at the search warrant?
I'm pretty sure I did. I can't say for certain, but I'm pretty sure he showed me.
Okay. Do you have independent knowledge that a confidential informant was or was not used to get the search warrant?
I don't recall, to be honest with you.
Okay. But Mr. Hinton was already on your radar or target of your homicide investigation, correct?
He was a person of interest. Yes, ma'am.
Was there any other person of interest besides Mr. Hinton?
There were two people running away from the location, according to the neighbors. So there were possibly other people involved.
The location of the shooting of Mr. Bernstein.
Yes. Yes, sir.
And you indicated that Mr. Hinton, you were present when Mr. Hinton left the residence that was the subject of the search warrant?
Yes.
Did you personally observe Mr. Hinton in the house?
No, ma'am.
You observed him running from the property of the house.
No, ma'am. I was there. I wasn't allowed to be in the perimeter until after the search warrant or the location was secured.
Okay. So when you testified on direct that they detained him and transported him back, that's because you meant law enforcement, correct?
That's correct. And they detained him at the location he ran into. And I transported him to the house, which was about 2 or 3 blocks away.
Okay,
Back
so,
to the search of the house, the subject of the search.
okay. So you never saw him at the house, Mr. Hinton, and you never saw him running away from the house, correct?
That's correct.
And when you said that you went and transported Mr. Hinton back, you spoke to him prior to putting him in your patrol car?
Might have just asked him, is he okay? Something if he needed a ambulance because he was kind of skint up because he ran on concrete and ran to somebody's house, but nothing significant.
Okay, and when you say he ran into somebody's house in the concrete, that was what the other officers had told you, or that's what Mr. Hinton told you?
That's what the other officers told me.
Okay, so without testifying to what other officers may have seen or told you, you went to a location and Mr. Hinton had been detained, is that correct?
That's correct. It was notified via radio.
Okay, and then you transported Mr. Hinton back to the location of the trap house where the search warrant was being executed, correct?
Yes, ma'am.
Okay, and it's your testimony that Mr. Hinton never said anything to you about phone or shoes or clothing or anything connected to the trap house? You just brought him back because of the search warrant?
And also he had no shirt on and no shoes. So, and also I wanted to see what they obtained from the search. So we were going back there anyway. So.
Okay. So I just want to make sure that I understand. Mr. Hinton never told you that he had property that was at the trap house where the search warrant?
If I'm pretty sure I recorded that. So I will have to listen to that interview to say 100% sure, but I don't think so.
Okay. And that's the recording of the statement that you took of my client when you say the recording?
Yes, ma'am.
Okay. So at this point, you have no independent recollection of whether you had communication with my client, which then led you back to the trap house.
I was going to go back there anyway because he didn't have any shirt on or shoes. And that's just the type of detective I am. I wanted to interview him and he ran out the house all of a sudden. So I wanted to get him his belongings, you know, because I knew he was going to go to jail for the search warrant.
How did you know he was going to go to jail for the search warrant when you didn't see him at the house or leaving the house?
They notified on radio that the drugs were recovered at the house.
So he was going to be arrested by Olson.
Whoever was going to arrest him, but yes.
Okay. And did Detective Olson or another officer advise you that they were going to arrest him, or did you just make that assumption?
I made that assumption because they advised that narcotics were found inside of the location.
Okay. So it's your testimony that you have no independent recollection right now as to whether you interviewed or spoke with my client regarding property that he may have had at the trap house.
I would have to be 100% sure. I would have to listen to the audio now.
Okay.
But it's audio of the interview that occurred later on down at police headquarters.
No, I believe I have to actually listen to it again. I believe I started recording as soon as I made contact with Mr. Hinton with a pocket recorder.
Okay.
And in fact, Sergeant, sorry, I almost said detective.
No problem.
You started the recorder when you made contact with Mr. Hinton after he had been detained because you were interviewing him, correct?
I started recording because I wanted to interview him. So yes, ma'am.
Okay. So you asked him questions in the patrol car?
After, I know I asked him questions with patrol cars after I read him his Miranda rights, but I will have to listen to the interview again to be 100% sure.
Okay. So you, just to make sure I have the sequence correct, you were notified by law enforcement that they had detained Mr. Hinton at a location within a couple of blocks of the trap house, correct?
Yes, ma'am.
And that when you went to pick up Mr. Hinton to transport, you read him his rights per Miranda, correct?
On that scene when he was transported?
Yes.
Are we now relitigating something that's been litigated? I don't want to spin our wheels on something that you've already argued and won and been affirmed.
No, Your Honor, respectfully, I'm trying to make sure that my questioning of the sergeant is clear, that any communication that he had with my client regarding shoes, phone, or anything else came after he had been Mirandized, which would fall under the Supreme Court's ruling, which is part of what we had already suppressed, which suppresses then why he went back.
Okay.
If the court's ruling is that this is already covered, then
No, it's not. You should ask your questions.
okay. Thank you, Judge. Sergeant, do you need me to repeat that question?
Yes, please.
Okay. Would it be correct that any communication you had with Mr. Hinton on June 10th, after you picked him up from law enforcement, that you read a Miranda prior to having communication with him?
Any communication as, are you okay? Do you need an ambulance? Does that count, ma'am?
Any communication, yes.
I have, like I said, I have to listen to the statement to be 100% sure. I don't want to tell you something I did and I didn't do.
Thank you. Thank you, Judge. No further questions.
Okay. Ms. Convery, any redirect?
No, I don't have any redirect for this witness.
Okay. May Sergeant Young step down, and is he free to go?
Yes.
Ms. Young?
No objection. Judge.
All right. Thank you, Sergeant, for your time. Ms. Rivers, are you good continuing? Do you need a break?
No.
Okay. I'd like to talk about the demurrers now, if we can. I guess I'll start with you, Ms. Young. You have two motions to quash / demurrers. You articulated, as I asked you to, why there were two and what the difference is. And I think we're going to spend most of our time on the gang counts. I'm curious, in one of your motions, you seek to quash every single count because they are fatally defective. And I've looked at the indictment, and they are remarkably similar to every other murder, sale of heroin, aggravated assault indictment that I've ever seen. So I'm curious what's so different about this count 4 murder, count 5 felony murder, that it has drawn a demurrer and motion to quash. Because I suspect that other attorneys faced with similar indictments weren't ignoring the opportunity and passing on the opportunity to have a murder dismissed because it wasn't properly pled. So if we could focus on the non-gang related ones first, I'd like to do that because I'm confused by those.
Okay. It's funny, Judge, when you were saying that, it reminded me of Passover. And I don't know if you have had, if there's any Jewish people in your family or if you have friends, but there's always a question, why is this night different from all other nights, right? And that so I apologize if I started to smile while you were speaking, and I wanted to explain that it brought me back to Passover Seders as to why is this night? Why is this different from all other indictments?
Right.
Yes, sir.
And so my question is, to riff off that, is why is this murder allegation that alleges that on the 31st day of May 2016, Mr. Hinton did unlawfully and with malice aforethought cause the death of Kaishan, Kaishaun, Bernstein, already spelled, a human being, by shooting him with a handgun? That to me ticks off all the elements. And more importantly, not because the way things have always been done means they're right. That is the essential language of almost every murder allegation I've ever seen. So I'm curious why we've hit Passover for this count 4.
Thank you, Your Honor. Your Honor, in response, and I believe the court is speaking of the motion to quash or dismiss general and special demurrers as to the indictment and not the one that specifically lists counts 1 through 3 and 6. Am I
Correct. That is correct.
Okay. Your Honor, the purpose, it's funny when drafting a motion, very often, and I can only speak for myself, things seem so clear when you're drafting, and then sometime afterwards, upon reflection, you realize, wow, that really wasn't as carefully tailored as I had intended it to be. I would have to respond in that fashion, Your Honor, that certainly upon reflection, count 4, of the 2018, the 18 SC 162373. I would have to withdraw any objection as to count 4. I believe that my intent was to specifically list counts 1, 2, 3, and 6. And that what I was attempting to do was to place an objection that there was verbiage in the indictment separate and apart from the allegation of it being a gang allegation. And that's why the two motions as particularized have some similarities and also are different.
So we don't spend too much time on this. This is why I asked you in the scheduling order to help me and presumably Ms. Convery understand what the difference was between your two motions to quash, because I suspect if I ask you then to read count 5, which is an aggravated assault, which is alleged, I believe, properly and sufficiently, and then we press on with every count other than 1 through 3 and 6, you'll say, upon reflection, I note that they're sufficiently and properly pled. It seems like rather than withdrawing simply your challenge to count 4, the proper thing would be to withdraw the motion to quash that says every count is defective and move forward on the motion to quash 1 through 3 and 6. Those are the 4 counts that implicate street gang activity and are, I think, more typically challenged in the way that you challenge them, even though I think they're pled, I think consistent with what the elements of the crime are, it merits discussing them for a whole bunch of reasons, including things we've already covered this morning about how a jury processes a case when you layer on top of a shooting or a murder the allegation that it was gang related. But I don't mean to litigate for you. If you think that there are other counts beyond the 4 gang counts that are facially insufficient and ought to be quashed, I want to give you a chance to argue that so that Ms. Convery can have a chance to counter that argument.
Your Honor, begging the court's indulgence, I would ask to withdraw that motion.
Okay. So then let's hear, please, about your concerns about the 4 gang-related counts, and then Ms. Convery can respond.
Thank you, Your Honor. Your Honor, in terms of the motion to quash or dismiss and or demur as to counts 1 through 3 and 6 of the indictment alleging criminal gang activity, it's the defense's position that the way the indictment has been crafted, that the counts are conclusory. They fail to put my client on notice or able to properly form an intelligent defense as to what behavior is, from the state's position, complained of in terms of they're alleging he violated the criminal code. Very often in charges, especially gang charges, there are what I refer to as a to-wit, although in Georgia we don't do that. In Florida, they do a lot more of to-wit this or to-wit that, specifically. But in count one, they're alleging that between March 29th, 2016 and May 20th of 2017, which I believe is about 14 months, that there was activity that they accused my client of being involved in, which says he's associated with a criminal gang called the Bloods, and that he participated in criminal activity through the commission of enumerated offenses. But the enumerated offenses are just the offenses that are also now joined in the indictment. So it's tantamount to saying that from this charge that there was no prior gang activity, there was no prior gang involvement, there were no prior instances of my client being involved in anything before the time period in this indictment.
Why? I guess I don't follow that. It is, I agree with you that the way it's pled is that it alleges that Mr. Hinton, starting with the earliest chronologically of the conglomerated crimes in the indictment up through the final one, those were all actions he took in furtherance of the gang. That's my shorthand. That's what it says. I'm not aware of a requirement that the government allege, oh, and there was this other stuff not in the indictment. They may need to prove that up, as you were articulating earlier this morning, unless this is one of those rare cases where the first alleged criminal conduct in the indictment was the Initiation Act, then presumably the state would need to show at trial that Mr. Hinton was already associated with and active with, here's in specific, the Bloods gang. But I don't know that they have to allege that. They just would need to show it either in this pretrial hearing that we may have, not today, or at trial. But I'm not aware of there being a legal requirement that they plead in the indictment. And by the way, Mr. Hinton has been a member of the gang since 2015. And on his left arm, he's got the word Bloods. And on the right arm, he's got the phrase death to the Crips or what. They could do that. You'd probably try to have a lot of that removed from the indictment because I don't know that it's pertinent to the charge. It might be relevant at trial. But why? What's your basis for suggesting that they need to allege in count one that Mr. Hinton did these other gang-related things before March 29? Because they argued that he did this, he participated in gang activity by doing these things. Not that he started with or he ended his time in the gang, but that these things are gang participation things.
Judge, if I understand the court's question, my only response is that in my experience, when somebody is involved in investigating from law enforcement standpoint, they're involved in investigating gang activity, they develop profiles, they put together pictures, they form charts and diagrams of who's involved in the gang, who they believe the leaders are, who the initiates are, and they have a plethora, for lack of a better word, of information that prior to an arrest that documents from their perspective that a person is the member of a street gang and the name of the street gang and what their participation is. None of that has been given in discovery. Because there's been no discovery about any prior gang activity or documentation. And every prosecutor that has worked on the case that I've had contact with has been very, very conscientious about getting as much discovery as exists to me, including, of course, Ms. Convery, who just sent over more discovery. So my objection is not to the lack of discovery. My objection is that because of the lack of discovery, there's nothing that shows my client was involved in gang activity except their allegation in the charge that it says while associated with a criminal street gang. So either
What if, I better understand now, but what if the way the state was going to do that was by calling Fred Jones, former or even current Bloods member, who for whatever reason is going to testify, I was in, here's how you get in, and Lil Bro joined with me in 2015, and he was one of our most productive members, selling heroin out of that trap house. He had a short temper. He did shoot a few guys, all for the gang. Love it. It was great stuff. We're real proud of him. One of the best Bloods ever. You might not know that if the state knows that only because they've chatted with Fred Smith, but they didn't record it or this or that. I mean, you learn that because Fred Smith testifies. If that's how the state's going to do it, is through the expected testimony of a witness, is that not a sufficient way of proving up what's alleged? Because you're attacking how it's alleged. You know, a demurrer doesn't say you need to dismiss it because the state doesn't have evidence. That's what a directed verdict would be for, not a demurrer.
And I understand what, I'm not aware that there are witnesses, civilian witnesses that have been listed. None come to mind. And certainly I think there's about 200 witnesses right now. Between all the cases. So unless it's somebody who's already been disclosed that the photograph was shown to, that we've just heard testimony about, there's nothing that would support while associated with a criminal gang. They're talking about 14-month period of time where the only allegation are the other charges in this case, not other charges. If there was testimony that they were going to elicit from a civilian or officer as a witness, law enforcement, that says, oh, by the way, there's 2 other crimes or 5 other crimes that we're now trying to bring in to this case without having disclosed them, then that's an issue for 404B, which we'd already filed a motion in opposition to in a request for an evidentiary hearing, anticipating that there might be 404B that we don't know about yet. So the only way I can answer that, Your Honor, is that unless they're bringing in evidence of crimes not charged, the only evidence is the charges in this case, which do not substantiate while being associated with a criminal gang. And specifically, the Bloods criminal gang did participate, or does it say did, participate in criminal gang activity through commission of at least one of the offenses, which means that the only way they're trying to establish that he's in a gang is by the charges that he's charged with in this indictment. If the cases were separated, as they were initially, and the state, with the court's permission, tried Mr. Hinton on those gang charges on a different indictment first, and then came back to try the homicide, then that would be evidence of prior activity that they could then bootstrap into this.
But what's the prohibition on, setting aside the severance issues that you've raised? So we'll get to that. But assuming that it was appropriate to join all these offenses, why can't the state document Mr. Hinton's purported role in the gang and association with the gang in one indictment? Here's how he got started. He was, the oldest thing is shooting Sean Brousseau, Brouusseau. If that was his initiation act, they're gluing them together, and they think there's a reason to have them all glued together in one indictment. Why is that improper? As opposed to saying, well, you have to charge them separately. And if you do that, then you could get them into the murder and drugs. Let's say the murder and the drug house stay together. Temporally, they're very close, and maybe arguably there's a gang connection there. I don't know that the case law says, no, you have to, even though maybe legally you could have joined them, we're going to make you sever them because you have to bring in something not charged in the indictment as proof of gang membership.
Thank you, Judge. The only response that I have is going back to my motion, page 2, item number 2, paragraph 2, coincidentally, which specifically cites to, in the interest of AD, a child, and in the interest of JW, a child, where the Court of Appeals in Georgia states specifically that the underlying crime committed in the case cannot serve as proof of the necessary gang activity, and cites to Supreme Court of Georgia's decision in Rodriguez versus State, which is, of course, Georgia Supreme Court, which says the commission of an enumerated offense by the defendant is not itself sufficient to prove the existence of a criminal street gang. If it were sufficient, the nonsensical result would be that a member of any legitimate group could violate the act merely by committing an enumerated offense, which, upon my reading and my perspective of the case, requires that there be independent evidence of other acts prior to being classified as criminal gang activity or being involved in the criminal gang. And the purpose, from my understanding, Your Honor, is to stop law enforcement from saying any group of 3 or any group of 2 who may have independent connections to a gang does not inure to the entire group. So Mr. Hinton allegedly being present when there is gang activity doesn't mean that he's involved in a gang and part of the gang activity, similar to in a drug case where somebody could be merely present, and mere presence is not sufficient for even constructive control of a narcotic. So I believe that it's the court trying to separate and not have people who are in the wrong place at the wrong time lumped in with people who may be doing things that are illicit without evidence that they're already connected. And therefore the prohibition against using the crimes charged to bootstrap, basically.
Okay, I think I follow you, but it still strikes me as a proof problem for the state rather than a pleading problem. You know, demurrer attacks the pleading. And what you're helping me understand is that per Rodriguez and that subsequent case, it is insufficient for the state to prove association. That's the thrust of count 1, is that, hey, Mr. Hinton, while associated with the Bloods, did these other things.
In furtherance of gang activity. Yes.
Right. The state needs to prove these things up, and it's not sufficient to say the proof that Mr. Hinton was associated with a street gang and did things in furtherance of gang activity is what we've charged him with substantively.
Yes, sir.
So the state needs to have something more. I don't know, they need to plead something more. They need to have something more. And you've told me you're not aware of what that would be because you don't have a report from an expert, which you'd be entitled to if an expert's going to testify, or at least a summary of his or her testimony. And you're not aware of a civilian witness who's going to come in saying, I was or am a Blood, and let me tell you all about Lil Bro. He was one of our strongest OGs. You're not aware of that. But again, that seems like a proof problem for the state. If all they had in the end was, see, he shot these 2 guys, that means he's a Blood. And so this was in furtherance of, it's become circular per the Rodriguez case. But we don't know what the state's going to do. And Ms. Convery will likely share some of that when arguing the severance motion. But I don't know, this is what I run into with demurrers, is that defense lawyers say, I don't know how they're going to prove it. And the answer is, that's not your problem. If you have no concept of how to defend because you can't tell what you're charged with, then we're in the heartland of a demurrer. I can't tell from this allegation. What is it you're saying my client did? I read count one to say, and I'm simplifying it by leaving out some of the many allegations in there, that Mr. Hinton, while associated with the Bloods, killed Mr. Bernstein, and that murder was in furtherance of the Bloods.
And Judge, I think I understand what the court's saying. And going back to my mindset, 2 years ago, I believe that's why I filed the motion to quash or dismiss and or demurrer, was so that depending on how the motions were heard, that if there was going to be evidentiary motions, certainly it would touch on those issues.
Mm-hmm.
And then the officer could indicate, well, there was prior gang activity, and that there's something independent that we documented. Instead of just filing a demurrer, I think I filed one prior to this case, in my 30 years of practice, one demurrer.
Okay.
It's not something that I do as a matter of course. It's something I do because as the court indicated, and I researched this again, just to make sure there was nothing new online. But I don't have internet access at this point through my laptop, or I would be bringing up that case where they differentiated. I think it was a 2019 case where the Georgia Supreme Court differentiated between somebody that was complaining, and it was a homicide case where they were saying that a demurrer should have been granted, but in fact it should not have been, because it was specifically pled that the baby was shaken, causing the death. And they were distinguishing, again, it's on my laptop, between what's needed to be pled for a demurrer, as the court has so clearly stated. In this case, if the court's position is that independent of evidence, that's a proof issue and not a demurrer issue, then I would certainly defer to the court and proceed only on the motion to suppress or dismiss.
Okay. Well, I don't have a position yet. I'm developing it by hearing from you and from Ms. Convery. Why don't we hear from Ms. Convery a bit on, I know we focused on count one, but I think your argument translates the same way, Ms. Young, for counts 2 and 3. Count 6 is just derivative. Count 6 goes away if 1, 2, and 3 go away. Count 6 is a felony murder predicated on gang participation. So if count 1 is gone, you can't have count 6. So you are correctly including 6 in your assault on 1 through 3, but it's sort of like punitive damages. If you don't have your tort, punitive damages goes away as well. So 2 and 3, I think I understand your argument would be the same. Where is there evidence of Mr. Hinton's connection to participation in a street gang beyond the allegation sort of internally that because of these things we've charged elsewhere in the indictment, he's doing gang things?
Yes, Your Honor. And to follow up just briefly, if there are witnesses that specifically are going to say, we already know he was involved in gang activity, then my objection to 1, 2, and 6 would then be further limited to while previously associated. And that way, there's no confusion, at least from a defense strategy standpoint, that there is other acts, whether, and of course, that would be an issue for testimony for court, independent of the ones that they have listed. The way it's pled and the reason for the demurrer was because it appeared that the only thing that was being listed as proof of his gang activity was the charges that they still had to prove. So it appeared
the Rodriguez problem.
Yes.
Yeah. Okay. Well, thank you for that. So, Ms. Convery, as I understand the indictment, which you did not author, the gang participation statute 1615-4 is used in 3 different ways. There is these crimes were committed in furtherance of A. There is a use of C, which is basically making money through gang activity.
Right.
And then there is an H, that's count 3, which is threatening people in furtherance of or in connection with gang activity. So it's participation, as in committing crimes in association with making money and threatening. And then there's the felony murder count that's just sort of tied into the first count.
Yes. So the state's position on just talking specifically about the way each of these gang counts is pled in the indictment is that they are appropriately pled and that they track the language of the statute. The statute, the 1615 the gang statute, really holds me to the need to articulate these 3 essential things: that there is a gang, that the defendant is associated with it, and that the defendant committed one of the outlined predicated offenses, or a predicate in this case. I also will need to show a connection between the predicate offense itself, the underlying charged crime, and that association with whatever criminal street gang. In this case, for each of the counts in the indictment, it's very specifically pled. And even though I didn't author it, I put in a phone call that this looks pretty good to me, actually, for someone who's doesn't author a lot of these. And it's, if anything, it's actually more specific than a typical indictment because it specifically names the gang. Of course, it articulates with specificity the predicates in, he alleged, which count specifically he's referencing in the predicate because it got a little bit intense there with all the joined crimes. When it comes to the C and H subsections of 1615 he tracks the language of the statute.
Is he Mr. Sprinkle? Who is the author?
Pinion.
Oh, Mr.
Actually.
Pinion.
Yeah.
Okay.
But he tracks the language of the statute almost exactly, and that's really what's required of me, and that's why the state's position is that it's appropriately pled. I did want to mention just specifically the discovery issue. I was trying to review both of these originally filed motions and then the defense counsel's response to the court's request to kind of more specifically get our arms around that. I did find a case that's, in my opinion, on point for sort of the discovery issue generally. And
when you say discovery issue, meaning Ms. Young's observation that as she reviews the voluminous discovery in this case, she's not seeing any evidence that she could put her hands on that would be how the state intends to prove that either 1, the Bloods are a gang, or 2, that Mr. Hinton is associated with that.
Right. Yep. That's
Okay.
exactly what I mean. The defendant certainly legally entitled to know the particular facts that constitute whatever I'm alleging is the violation in a given count. However, and what's necessary to be on notice for, to prepare yourself for trial. And it's not necessary for the state to spell out and I think the court already talked about this, but in the body of the indictment itself, how I'm actually going to get there, the specific way I'm going to be able to prove 1, 2, and 3 in this case. And the case, the court, again, I already talked about it, but the case that I cited in my response is Scruggs versus the state, and that's SCRUGGS, and that's 309. It's a Georgia Court of Appeals case. It's from 2011.
You gave me the first number. Was it 309 Court of Appeals?
569.
569.
2011 case. That holding it goes on to talk about, it's a special demurrer that was filed in that case, and the indictment charged 2 defendants, and it didn't specify which of the defendants had the gun. There was a complaint about, well, you didn't say with specificity who did what in the actual crime, and the court went on to say, that's just really not necessary. I don't know that my response gets a lot more complicated than that. I promise I'm going to talk about my theory related to the gangs, but it's really more appropriate in Severance. As far as the demurrer itself, again, the state's position is that these are all sufficiently pled to put the defendant on notice of what he has to be prepared to defend himself against at trial, that on a specific date in this county, Fulton County, he committed at least one of the enumerated offenses with the intent to further the criminal interest of, in this case, we actually articulated the gang, the Bloods, while he's associated with that group. And I think they're all, and I put this in my response, but I believe each of them are detailed enough to protect the defendant from a subsequent prosecution for the exact same thing that's alleged, and that's what's required of me. So
share your thoughts about Rodriguez. And I read it long ago. I haven't read it recently. I trust Ms. Young's distillation of it. She's probably read it more recently, certainly cites it. But if Rodriguez stands for the proposition that the crimes charged in the indictment can't be the sole proof of membership, is that your understanding of Rodriguez?
So
If it's not, what is your understanding, and why is Rodriguez not a problem for this indictment? Or put differently, why does this indictment not run afoul of Rodriguez?
So that's not my understanding of the really core holding of that case. I think the situation in the initial case cited by defense counsel is different here, where they're sort of charging a novel group, where they're saying you can't just make this a gang because a predicate happened here. And you can't use the predicate offense you're charging in a given indictment as also your evidence that a criminal enterprise exists, and this is what defines it.
Meaning, hey, these 5 guys allegedly ransacked a bunch of cars in a parking lot. We're going to call them the car ransackers. And what do you know? They've been charged with car ransacking, so it's a gang.
Exactly.
Okay.
That's certainly not the situation here. The state expects the evidence at trial to be expansive as far as the organization of the Bloods, and more specifically in the defendant's case, the Inglewood family gangster Bloods. I have served for, I don't want to like really go down the rabbit hole of discovery, but there is, from the state's perspective, a pretty, not a crazy amount, but discovery on the issue of this particular defendant's.
The Inglewood family gangster Bloods, and that discovery would be constituted of internet searches, or a report from a detective, or Joe Inglewood himself and his interview telling, here's my family.
No, so not that.
Okay.
There are images, specifically photographs, hand signs associated with that particular group. I know listed on, I think it was already on Mr. Pinion's supplemental list, but there's a detective, Mark Belknap, who I anticipate will be the gang expert on behalf of the state. I certainly, I've already been in contact with him about the specificity of what he'd actually testified to in this case. I wanted to do that before I argued these motions today.
Is he an Atlanta police detective?
Yes.
Okay.
We have that criminal street gang is based on the West Coast, but has a presence here in this community, and
Meaning the Bloods, or the Inglewood Street gangster Bloods?
Inglewood family gangster.
Sorry, Inglewood family. That's a West Coast gang.
It's originally based out of, yes.
Got
Wisconsin
it.
on the West
But it
Coast.
has a cell, or whatever you call it, here.
Yes,
Okay.
yes. I think the indictment is appropriately charged with the blood specifically.
Inglewood E or I?
IFGB, which it goes by sometimes, or you'll hear If Gang. It's also referred to as 9 Deuce here locally, which is 92 is a series of streets on the West Coast in LA. But and there is, for what it's worth, also an interview, at least 2 that I've been able to just quickly review to get up to speed in order to talk intelligently to the court about some of these issues. Interviews with lay people or witnesses in this case that have been served in discovery that reference this defendant's criminal street gang affiliation.
His connection to, would you call it 9 Deuce?
Yes,
All right.
and generally the Bloods in those interviews.
Great.
So yes, so the state's position on the cases cited on that specific issue is that they don't apply here. That is certainly a concern that the court outlined, but it's not one that applies to this indictment. The state is, in this case, probably more specifically than a lot of DAs, I'm very aware of what I need to do to make this case. I don't think any of the outlined concerns about the statute, either from the court or defense counsel, are inappropriate, but I think they're proof issues. And I expect to hear them and have to be prepared to defend against them at a motion in the trial.
Okay. Let me see if Ms. Young has anything in response. I appreciate how she's articulated this, and that she recognizes if I end up disagreeing with her perspective on it, the issue doesn't go away. It shifts to, then there's a proof issue for the state that they'll need to meet. This is an effort to sort of head that off at the pass. If the state was going to prove things by pointing the jury to the underlying offenses, we get into some of that circularity that, if not Rodriguez, then in the matter of the juvenile case you mentioned, says that's not how you ought to do things. Because then per Rodriguez, you start empowering the prosecutorial side of things to criminalize as a gang any case that has more than one defendant. Okay.
And I appreciate the court allowing me to argue motions and listening to the arguments. I do tend to file more defensive motions than a lot of my colleagues do. Just trying to anticipate issues that may come up during trial so that we have a clean trial and no mistrial issues.
Clean trials are good trials. All right. Then let's shift to severance. We've got a little bit more time before I have to call it to a close. I didn't know we would need this much time. I'm glad we have it, but I have a Zoom session in about 25 minutes that I need to go get on. The last, where did my agenda go? Item I had is severance. Ms. Convery has been waiting for, so she can talk about the state's theory of the case. And I'm going to let Ms. Convery start with that. It's actually a defense motion seeking to unstitch the Frankenstein indictment and return one arm here and one arm there to the original indictments. I think what will naturally flow out of this is then also a discussion of 404B, because try as I might, I couldn't find a 404B motion, but that's probably because the indictment now has everything in it that the state would want to use, minus perhaps, and this was another flag that I think Ms. Young helpfully raised, if any of the evidence that the state was going to use to connect Mr. Hinton to IFGB is, oh, and by the way, he broke into a car that was a Crips car and only Bloods would do that. Of course, that's criminal activity. I don't expect you would be that ham-handed. Just want to make sure we think through that, that sometimes it seems innocuous, but graffiti is a crime. So if the way the state was going to show, here's a video of Mr. Hinton saying, Lil bro, 9 deuce forever, that might be very compelling to show membership and association, but it's probably something we'd want to push through the 404B screen before that video would be played for a jury. And obviously 404B becomes relevant if I decide that we need to break this big indictment apart a little bit if you're going to use any of the pieces. And let me preview for you my concern, Ms. Convery. Your Exhibit A was very helpful, and I was able to break out the counts of the current indictment into their original pieces. And I'll note that the current indictment spans a 15-month, maybe 14-month period from March of 2016 all the way through May of 2017. Some things seem more connected than others. The common thread, I assume I'll hear, is, but these are all related to IFGB and were all allegedly perpetrated by Mr. Hinton in furtherance of. May be true, but boy, is it a strained temporal relation to say the main thing we're here about, ladies and gentlemen, is the murder of Mr. Bernstein in May of 2016, but you're also going to hear about the assault of Mr. Knox effectively a year later.
Right.
And it may have been that Mr. Hinton, I'm making this up, Mr. Hinton, but may have been Mr. Hinton is shanking Knox saying, you know, die you Crip, IFGB forever. And it's clearly gang related, but it's a year later. And so it's harder with the severance analysis that I need to apply to say, boy, the jury should hear about all that in one big indictment rather than maybe that is proof of the connection to the gang, although a response would be, as proof in May of 2017 doesn't mean that he was rolling with IFGB in May of 2016. And so it would, I don't want to allow something that happened a year later to be proof of association and furtherance of something a year before. So my main concern on the severance piece is how does the Knox stick with it? The others are assuming you share what Mr. Pinion had already forecast a bit, that look, these others are temporally, they're real close. And it sounds like there's a drug business going on, and then a couple of people get shot and one dies. That is, to me, a lighter lift for you than to say, and also Knox should be patched in there as well.
Right.
So with that preface, take it away.
Like you can't see me behind the computer, so I'll move over here for you.
Okay.
I did Exhibit A because I needed it. And I was like, if I need it, there's a chance he may want it too.
Very helpful. Thank you.
So yeah, I had to, because I did not create this indictment personally. I had to, one, learn this case and then sort of walk back through Mr. Pinion's thought process. Had a couple conversations with him. I call him
what are you thinking?
Yeah, I call him the mad scientist of indictments because he's always redoing indictments. But in this situation, I was able to get on the same page with him and understand. And I think it actually proved to be helpful for me to maybe articulate back to you why I think this is.
Give me one quick second.
Sure.
The chief judge just sent something. You don't have to go. Oh, I was going to say, don't go away. All right, sorry.
No problem.
So you had been talking with Mr. Pinion to try to understand his thought process in why it made sense, effectively procedurally, that's what we're
Right.
talking about, to mash all these together.
Right. And when I created the Exhibit A for the court and for myself, I wanted to take a look at, of course, the proximity temporally, how close these incidents were related to one another. I saw just by the way they were charged on the face of the indictment, they're going to have, I could see right away, okay, I get it. But I wanted to make sure they were close in time and close in location, because I think that's an important part of the state's theory about why these are appropriately joined. And then the assault at the jail is a little bit of a different argument. And I certainly understand and anticipated that may be one of the questions that the court has. And it was a question I had as well. So for what it sounds like the court understands, but I will say it for the purposes of the record anyway, that the state chose to charge the indictment this way as far as all of the 2016 incidents. So speaking specifically about the March 2016 aggravated assault of Mr. Brousseau, the March 2016 sale of heroin at 407 Sunset, and
Which is only a day after the assault. I mean, those two are
Right.
super close
right, and the
temporally.
exactly, and they're also very close in location. The aggravated assault actually happens at 437 Sunset, and then we're at a house a day later with a heroin sale issue on the 30th of 2016, March 30th. Then in May of 2016, we have the homicide that involves Mr. Bernstein, and that's at 409 Cairo Street, and it's less than a mile. Cairo Street, Cairo.
It's spelled like Cairo, but it's pronounced Cairo, or you're saying?
I don't know. I was like, oh, I might be saying. I think you're right.
I don't know.
Yeah, and it's less than a mile, and these are all would be considered part of the neighborhood or the Bluff neighborhood that Sergeant Young spoke about earlier. And then we have the June 10th, 2016 heroin arrest that the court has now heard about in detail, or at least a little bit of detail, and that's from 416 Lindsay Street, also right around the corner. And all of the locations I just listed off to the court are come up and are relevant to the larger homicide investigation. The conversations that Sergeant Young talked about today occur in these areas. There are multiple, the state will allege, sort of businesses or trap houses that are running in this community within, less than a mile radius. The state's position, and I expect the evidence to show at trial that this defendant is essentially promoted in his organization, and the organization is a criminal street gang, primarily Bloods, and the criminal street gang has its foundation really rooted in narcotics. Money is made that way, and it's run very much like a traditional business where people are working shifts at the locations and needing to be certain places. And when people are in custody or getting picked up by APD, that's not good for business because there's no one.
Hold on a second.
Excuse me for interrupting. I'm fascinated by what Ms. Convery is saying, but it sounds like she's testifying. These are not legal arguments that she's making. She's testifying to what the facts and circumstances are behind procedurally what was done. So I would have to respectfully object to any of her testifying type comments and offers because there are no witnesses here to testify to what she's attempting to put into the record before the court, other than just saying that they're connected or she's spoken with law enforcement who have told, who have said certain things to her.
Okay.
We've kind of gone a little bit beyond.
Well, I appreciate your concern. I am comfortable in the context of a severance motion to rely on proffers from officers of the court on either side. So I do appreciate that what Ms. Convery is saying now is what she expects the evidence will be. I don't think I've ever had a severance motion where a witness had to testify. This isn't the forum in which I'm going to conclude that let me say this differently. If I decide that I need a pretrial evidentiary hearing about the propriety of keeping the gang allegations stitched onto all the other things, we'll still do that. This isn't a substitute for that. This is Ms. Convery's opportunity to say, because I think the evidence at trial will be X, this is why I think it's appropriate for these counts to remain together in front of one jury. And I'm all right with that being a proffer. So your objection is noted, but overruled.
Thank you, and I certainly have the utmost confidence in the court's ability to make those legal distinctions. My objection was to her testimony.
Sure. Okay.
Thank you, Judge.
You bet.
So the state's position is going to be that this operation is not just based on one house in the area, but it's a series of houses with multiple employees and associates, and this defendant is one of them. More specifically, I expect the evidence to show that this defendant was essentially promoted within this organization.
So you've said that a couple times. I'm just curious. This gets to Ms. Young's point. We don't have Belknap in here or someone. Who is it or how is it? Who would show or how would you show something as intimate as someone getting promoted? It's easier to say, here, we did surveillance in these houses, and it's these same 5 guys who are in the house selling the drugs. And what do you know? They all have the same tattoos, and they all have a red bandana in their back pocket. I'm simplifying it, but that's a way to do it. And that may well be sufficient to show there's an organization, it's coherent, they're identifying, et cetera. Getting the intimacy of, and he had this rank or he got promoted.
Right.
Belknap saying that is interesting, but kind of that's his theory because now Mr. Hinton gets to stand on the top step instead of the second step at the house. Mm-hmm. And I'm not asking you to reveal something that would reveal critical trial strategy, but how do you show something in this case as internal as Mr. Hinton got a promotion?
So it's my basis for saying that is from a custodial, or not, it is actually a custodial, but an interview with an associate of this enterprise. Okay. Someone who works with them day in and day out. There's actually a different associate who gets killed, dies, and the defendant sort of takes that role in the operation.
But would you be sharing with the jury, or you're just sharing with me, so I better understand, would you be expecting to share with the jury that Mr. Hinton not only was involved with this group, but he took it seriously enough and did well enough that he got promoted?
I'm telling it to you now so that you understand the full context of sort of our thinking for joining them. I haven't gotten that far yet
Okay.
on how that works, but the basis for my knowledge about that specific intimate detail is from an interview with then Detective Young and another one of the members of this group.
And that's an interview that at some point has been given to Ms. Young among
Yes.
the many, many other things she's received.
Yes,
Okay,
yes,
great.
yes.
Press on.
So the defendant's working in this series of houses, and the defendant is, the rank. I brought it up because I think it's important, because the willingness and the feeling of a necessity to affect violence to maintain that status in this organization is closely tied not only to the nexus for the criminal street gang activity, but as to the motive for the doing of some of these acts, specifically the aggravated assault on Mr. Brousseau. State expects the evidence to be that essentially Mr. Hinton accuses Mr. Brousseau of stealing from him. And as a response to that, very, sort of publicly and openly, he shoots him.
And Brousseau, in theory, could talk about it because he's still alive.
Yes.
Okay.
And that, he has been interviewed, that's been memorialized, and in the police report essentially says, I spoke to him, he said, hey, you're stealing from me, and he shot me. That's also talked about in another interview with Detective Young and other associates of the group, sort of publicly known that he has a short temper, he shot Brousseau.
Okay.
The homicide itself, the allegations surrounding sort of the motive for why the homicide happened is a similar conflict with Mr. Bernstein. There is a period of time where the group working these series of trap houses is away in Miami. In the period of time that they're gone, one of the houses is broken into and some counterfeit money and some other items are stolen out of the house. Mr. Bernstein becomes a prime suspect for that. He had been previously asked to leave the house. He was working there before in the months prior, but it essentially been
Working meaning selling drugs, or
Yes.
working as in fixing the plumbing?
selling drugs.
Okay.
He had essentially been fired. I don't think it's that formal of a structure, but essentially he had been asked not to come back and return to that job. After he was a suspect in the break-in over the Memorial Day weekend, he was suddenly invited back. He's with another associate who says, do not go over there. Like, that's not a good idea. Mr. Bernstein responds to that location anyway. And later that night is killed outside one of the houses in that community I've been talking to the court about. When he is discovered the next morning and Atlanta responds to the scene, one of the things that's discovered in his pocket is a series of counterfeit bills that are consistent with what sort of the allegations are about why this happened. And then the court knows in detail, of course, about the June 10th heroin arrest. Again, it's out of one of these houses, which the state will offer evidence to show as part of a sort of larger operation.
Were there other people besides Mr. Hinton arrested that day?
No, I believe he's the sole occupant of the house at that time. I want to double check that. But I believe he's the sole occupant and he's subsequently charged for that. And there are no other co-defendants on that indictment.
Okay. And the sale of heroin, the thing that happened the day after Mr. Brousseau got shot, that was solely Mr. Hinton selling to an undercover officer?
Yes.
Okay. At a location that's consistent with all these things you've been describing.
Right. And so we've essentially got a coupled heroin sale with both of the shootings that are related to allegations of theft, sort of stitched into the framework of maintaining sort of a fearsome reputation and a reputation in the community that we're doing well and that, you can't come in and just take from us or something's going to happen.
The stealing that Mr. Brousseau allegedly did, what does stealing mean? As in, I wasn't looking and you took some money, or you were supposed to deliver 2 ounces of heroin and the person only got 1.5 ounces, or if you know, what is the stealing?
I still need to personally re-interview Mr. Brousseau, but my understanding of the conflict is about quantities, like you took more than you should have.
But it's related to drugs. It's not, I'm a big fan of Cheerios and there are no more Cheerios in the breakfast cabinet and I think you took them.
No, 100% related to drugs. And Mr. Brousseau is a user in that context, in that scenario. The So the state's position on those in the court, I know this court knows the law on severance, but essentially we're traveling under the proposition that these offenses are similar enough in nature to show a common scheme, plan, and motive. In this case, the state's position is. And of course, this court knows it doesn't need to mirror every single detail of each other. They don't need to be carbon copies of the same exact crimes, but they have to be similar enough in nature. I think the court already made an observation that they are very close in time. Some are just, one day after the other. And then for the state, it was important to also be able to confirm that they're close in location. Our theory of why these are relevant to sort of the common scheme and purpose of this group is because they are essentially affecting, and this defendant specifically, a stronghold on this community by way of these narcotics operations, which the state will show is tied closely to not only the business of heroin sales, but the business of the criminal street gang, the Bloods. So those are the reasons that those are joined.
Is heroin the primary drug? They found cocaine during the search warrant.
Heroin is the primary drug. The houses, I expect, if we, and I wouldn't offer this at trial, but the narcotics teams that are working out there, I think you could probably get whatever substance you might be in the market for in this community, but the primary substance is heroin in this particular group. So as far as the 2017 stabbing is concerned, that lapse in time is obviously because this defendant was in custody for a significant period from 2016 forward. And the state's position is that what happened there in 2017 in May is going to be admissible under 24-4-418 should this matter advance to trial. And so for that reason, I believe it's appropriately charged. The state, one of the things that the courts indicate that are one of the factors that you should balance when deciding if things are appropriately charged and if they need to travel together are the necessity of multiple trials and sort of balancing, okay, what evidence goes with what count. In this case, the state's position is that even though there are, and I know the court's noted it a couple times today, but a bunch of crimes on this indictment, they're relatively straightforward. Certainly the state's position isn't that the murder's not complicated, but as far as the complexity of the evidence that is assigned to each charge, it's nothing that the state thinks would confuse a jury or prevent a juror from working through, okay, this applies to this day, this applies to that day. The admissibility standard for 24-4-418 is a shall standard, certainly. Sure. It's a shall standard, and I certainly still need to survive the 403 hurdle. But here, when I have a jail-motivated assault, or I'm sorry, a gang-motivated jail assault, where the victim in this case essentially has a conflict with members of the criminal street gang, the Bloods, and specifically this defendant refusing to join or associate with their particular set within the jail, he's attacked violently for refusing to do so by this defendant. The state's position is that it absolutely is similar in nature, but because of the circumstances of where that occurred, it cannot be over heroin or the drug business, but instead is just channeled in a different direction. The 418 standard being shall, the state, believes that this evidence, specifically because it's got that criminal street gang element and nexus, would be appropriately before the jury in the form of a 418. And so because of that, I'm of the opinion that this indictment is appropriately charged with all of the counts that are before you now.
Got it. Thank you. So, Ms. Young, here is our situation. I need to go get on now, thanks to the chief judge, something I thought I had something at 12:45, but I have something at 12:30. I don't expect you to share everything you want to share in 4 minutes. So I want to understand the best way for us to wrap up. I can be.
4 minutes, Judge.
You can?
I can.
Oh, let's do it. I can be a couple minutes late
Okay, great. Thank you.
or 1 minute late.
Am I okay being heard from here? Oops.
From here, since I have a lot spread out?
Yes, ma'am.
Hear me okay?
Yes.
Okay. Your Honor, first is to the 404B, because I know that was mentioned at the outset. I filed a motion in opposition to 404B in 2017, well in advance of the state filing 404B notice as to the ag assault. and just 1 month before they re-indicted. So in terms of the sequence, there is an opposition to the 404B that predates that.
I saw that. And if I sever out the Knox assault, then we're going to need to have some discussion about it. I'll need to enter an order.
But not today.
No, well, we're having the discussion in part today, but there'd need to be a motion to have it admitted as 418 and maybe 404B. So that will create a separate procedural step we'll need to do.
Thank you, Judge. I heard everything that counsel said, and I respectfully disagree with her characterization of why the case was joined. And I certainly can stop it at 3.5 minutes or wherever I'm at if the court wants more information. But procedurally, this case was joined because the state wanted to give themselves a continuance. This was not motivated by, I think he should be tried on everything together. In fact, the case that 2016 homicide was indicted on October 18th of 2016, the same day as 16 SC 147090 and 091. They were indicted on the same day, and they were indicted separately, not together. The 16 SC 144750 was indicted 3 months before that, July 1st of 2016. So it now, at that point, gave the state 3 opportunities to join cases that they supposedly believed should be joined. Then the 16 SC 148466 was accused on 12/22/16. So 2 months after the homicide and the 090, and 5 months after the 750 case. So again, they had an opportunity to join them. The 17 SC 153897 was indicted August 8th of 2017, which would have been the perfect opportunity to indict on everything if this was a good faith joinder. But in fact, Your Honor, respectfully, the defense's position is it wasn't, and for this reason. The 16 SC 147091 was indicted on October 18th, 2016, which was after the date of incident of May 31st of 16. Judge Campbell issued a special set trial order on December 14th of 2017, giving a trial date, special set trial date of November 6th of 2018. And that
For the murder case?
for the homicide.
Okay.
Yes, everything was separate. They'd had 5 chances to join and indict. Over 2 years had gone by and they had failed to do that. It was specially set for trial by Judge Campbell, and his orders file stamped 12/14/2017. And there's to date been no objection ever entered as to that, where it specially says the case is specially set for trial beginning Tuesday, November 6, 2018. So 11 months in advance, it was special set for trial. And the order from Judge Campbell specifically says the deadline for filing substantive motions is 30 calendar days prior to trial. The deadline for filing motions in limine is 5 calendar days prior to trial. And then from the defense's standpoint, the important part is no extensions or continuances will be granted except for good cause shown. So what happened was 8 months go by, the state realizes they're coming up for a special set on the homicide. The other cases are separately indicted. They'd had 5 chances to indict and join the cases. They'd had almost 9 months of a special set order for trial. And it's at that point that they re-indict on 9/14/2018 and then submit the nolle pros to Judge Campbell. Now, in practice, for the record, and I know everybody's aware of this, but for the record, when the prosecution nolle pros and re-indicts, they have 2 choices. They can come into open court and say, especially with defense counsel there, and I've been on the case since practically the inception, hey, we're going to re-indict. This is our good cause because this is now going to take it off your trial calendar because we have 2 separate attorneys in 2 separate offices, C3 on 4 cases, Ms. Young and now Mr. Gavrin, who's deceased, on the homicide, and this is going to give us a continuance, but they don't do that. They just gave the paperwork presumably to Judge Campbell, who initialed it. There was no good cause shown. There was no showing that there was any explanation as to why they had to do it. There was no opportunity for the court to make a decision prior to giving consent as to why this null pros was happening. That never occurred. So I come to court expecting to try a case on a 2016 case, and I know I said 4 minutes, there was a little bit more than that, but it's been re-indicted and basically hit the roof. What do you mean it's been re-indicted? But that got rid of their joinder, got rid of the prohibition by the court saying you can't continue or extend this without good cause. There was no good cause. It's the defense's position that needed to be done in order for the court to give consent as to why it was allowing the null pros. And that didn't happen. So the state's attempt to backdoor all of this in by saying, well, the joinder is appropriate because the joinder is appropriate, totally circumvents the procedural posture of this case as to why it's not appropriate. The fact that they can do it doesn't mean that legally, procedurally, they should have in view of Judge Campbell's order. And I have a lot of other things to argue, but that was the main thing that I wanted to impress upon the court is.
Which dovetails with your motion seeking to unwind the null pros.
Yes, Your
Okay,
Honor.
now I better understand where that was coming from. Okay, well, I appreciate that. I need to go. I don't mean for you all to go. We can do more this afternoon, or we can reconvene. If you feel like you've gotten in front of me, both with your written pleadings and what you just shared, Ms. Young, what you want to share in terms of severance, and it wasn't on the agenda, but the null pros piece, then I'm comfortable moving forward and getting some rulings out on the motions to suppress, the demurrers, and the severance piece. We'll need to reconvene either way, because if I do sever something, then we're going to need to talk about 404B/418. We'll need to have another get together anyway, because if I'm not severing anything, it's a big ball of wax, and we may need to talk more about the gang counts. So you tell me your preference.
Judge, respectfully, I would ask if I can file a written response listing some of what I said and the severance, and also responding to what defense counsel filed on Friday.
Sure. How much time would you like for that?
30 days. And it's because I have a personal matter that's going to happen in 2 weeks.
Okay, so why don't we say by July 12th? It's a little less than 30 days. Is that all right? Or is that not enough time? Like longer than that?
Trial on the 12th and have a special set on the 14th.
So then how about July 19th? That's the Monday after. And that is more than a month from now. That's a month and 2 days. But I'm not rushing you. I mean, it's you and Mr. Hinton are the one who need to get into court for the trial. Would you like more time than that?
If I could have till the end of July, Judge, that would be
All right,
fabulous.
July 30th.
Thank you, Judge.
You always file it earlier than that.
Yes.
Ms. Convery, I'll let you know if I need a reply to the response or if I have enough in front of me. And we will go from there. And what you'll be filing, Ms. Young, is in connection with the severance, and I can move forward with the other things, or are you going to be filing things in connection with the motions to suppress and the demurrer as well? Because I want to know what I can work on and what I need to wait to work on.
Judge, I would like an opportunity to speak to Mr. Hinton.
Okay.
I suspect that it will be the severance, the 404B, and the motion to vacate.
Okay.
And
Let Ms.
whatever-
Nelson and Ms. Convery know what you're going to be covering in your response and what you're comfortable letting me move forward on. So I know not to issue an order and you're like, wait a minute, you were going to let me respond to that. I don't want that situation to occur. So I just need to know motion to suppress, demur, severance, 404B, which of those I can move forward on. My last request, I would like to get a copy of the search warrant from the June 10th, 2016 search. If you could get that to Ms. Nelson, she'll get it to me. I am sorry to run,
Thank you, Judge.
but I got to go get on my unscheduled chief judge requires you to join Zoom call. But I appreciate your time, Mr. Hinton. Good seeing you. Thank you, Ms. Convery, for your work. And Ms. Young, just let Ms. Nelson know what you're going to be briefing and what I can go forward on.
Thank you, Judge.
All right. Thanks, everyone.
We're then excused.
You are.
Thank you, Judge.
Okay, guys, I'm gonna close out this meeting, all right?
Thank you.
Thanks.
All right.
Did I talk too fast? No. Okay.
I'm way faster.
I used to be way faster.
When you speak up, slow down.
Yeah,
It's
yeah, that's why I'm used to the getting trouble for that.
I had a bunch of court reporters throwing things at me to slow down.
Oh, I feel like you're extremely slow.
Well, it took a lot of practice.
That's just how I talk in general, I think.
I know, me
so
too.
It's hard. You all set.
Surge protector. I was at an office the other day where the firewall in the office wasn't strong enough. I couldn't. The firewall that we had was complete with every cable. And it just kept kicking us out. Well, well, just disconnect your VPN. Disconnect my VPN and your security for a couple weeks. So now I bring surge protectors. I'm so sorry.
No, you're okay. I'm totally used to it. Whenever it's all right. But I responded anything close. So.
Please, I told the judge, it's like he kept calling, missing. You're talking to me.
Oh God, that's
It's
bad.
like this. You had to go to the bench, one of the judges.
Yeah.
You sassy old judge.
Oh God. Way old school.
So in the next 30 days or so.
Yeah.
If you're reasonable.
Yeah. Have you guys already talked about those?
We did. Yeah, who's gonna drop the homicide?
he was gonna drop the homicide. That's not the spirit of our conversation when I talked to him.
Which mostly numbers.
Yeah. I'm not so worried about charges, because I can do stuff with those, but had you guys talked about numbers at all?
No,
Okay,
yeah.
okay,
I think, from my client's perspective, the most important case.
sure,
So,
of course.
well,
Yeah, no, I know. I'm just saying that makes sense to me. I get it. I feel the same way, I think, about him.
when you listen to the recording, I don't know, and again, I can be wrong.
Mhm.
And I can't go through everything every time.
Sure.
Yes. And that's another thing about the shoes. So I understand why he's saying please, because he hasn't listened to it in a while, and I haven't listened to it in a
Yeah,
while.
I don't know that that's still, even if, I don't know that that warrants a suppression of the shoes. I don't even know that I would use shoes, because more importantly, probably that, I don't know that I would use them because I don't think there was any like testing done of the shoes, was there? I'm about to look at it.
I don't think they had like,
So I'm not
do
in-
the tracks.
I mean, they maybe should have, but,
We got to August. We have the same.
oh, this is my work. I'm just now getting used to it. I actually don't mind it, but I have a Mac at home
Oh, that's a
and
whole different thing.
it's way less sensitive. Like this mouse is so
Very
sensitive. If you
sensitive.
like look at it, it moves. And so it took me a minute to,
What took me the longest time was to get used to the numbers being on top and not to the side.
oh yeah, that's true.
That one just,
And I don't like not having a mouse. It's-
well, you can plug an external mouse in.
Yeah,
I actually have one. I have, sorry, I've been spending so much time out at Arizona. Have you ever tried these shoes before?
Mm-mm, they're comfortable,
God,
like clouds.
they are. This is the longest I've stood in heels in my life. When did you start putting that in the office?
So I've been here the entire time.
Oh, you have?
I sign fugitives, track and trace orders.
Okay.
So that business has never stopped.
No.
So yeah, I've been here.
I have a pretty funny story about that. Fugitive words.
Oh.
When I was a DA in Florida, and all of that, I couldn't get to judges, but there was a division, Judge Green's division. And he defended him to court and complained that it was the second time that he'd been arrested on a warrant, and it's not him, same name, close date of birth, but not him. So I asked the judge to do fingerprints in open court, which he did. He had his deputy take prints. I walked across the street to Lieutenant Burn. I don't know why I remember this, but, and I said, who was the head of fugitives at the time of the Broward Sheriff's Office, and I told him what was going on. I said, you can't have the same person arrested another time
Right.
incorrectly. To go over to the jail. I talked to the lady who's in charge of prints in the jail, who I also remember the name of the time. I just felt like I was,
Yeah.
dropping names. And she had one of either she or one of the people in her unit translated them to Henry classifications because they had just, I think they had just started using APHIS. This is a long time ago. And the Henry classification for prints, along with the prints, I walked back to the lieutenant and I said, please put in whatever notification, wrong person's been arrested twice, please run prints before you arrest. You know what happened? They arrested him the third time.
No, oh my God, terrible.
It was, but at the same time, it was like, okay. You know? So I'm gonna go pick up what you sent. Thank you very much.
Yeah, and if,
when you guys were first talking about it, I was looking back to my email to my video, just asking me to run this, and I don't even think I saw what he ultimately, I just said, hurry up and get it to her. So if you have an issue with them and you think one of them is missing, like an NCI, I know we have GCICs for everybody, but if you think somebody's missing something, just call me and I'll make it happen like that day.
Okay,
I
it wasn't the
just
GCICs that I needed from you, it was the NCICs.
Yeah, just let me know. I don't know
Okay.
what went out to you because I didn't have time to even look at it myself.
Okay.
I just know we ran everyone, but it's very easy for me to
Supplement.
run everybody again if I need to. They do both for me as a standard practice, so I don't see any reason why you wouldn't have those, but just call me.
Well, I appreciate that. Yeah, it was funny when we were in court, this law was like, well, you just have to ask for it. I'm like, no, that's GCIC, not NCIC. It's just like, no, it's not. So I literally did. I talked to the Secret Service. I emailed with the FBI and I emailed with the GPI here and said, look, did I misunderstand? Because a prosecutor just represented to one of the judges that I could get NCICs, and I always thought I could do it through an official teletype. And they're like, yeah, you can't. And I'm like, okay. The only other thing that we didn't do today
I'm just gonna text him right now. This is insane.
was the that part 4 of the motion to suppress that dealt with the prelim.
Oh, yeah, and we didn't really talk about the vacate issue, but,
No. So that's why I asked him. At first I thought I could do it in 4 minutes, and I did a lot in 4 minutes, but it's so how'd the case from yesterday work out?
oh.
The new homicide?
Oh, I actually haven't heard what the ultimate decision was, but I don't believe that anyone can be charged.
Oh, okay.
Maybe with some weapon issues, but I think.
So what issues?
Like, I don't know if the person was a convicted felon or if there's some issues with that, but as far as the actual murder itself, I think it worked out. Someone still lost their life.
You know, it's such a pleasure to be in front of this judge.
Yeah, he does.
Just the fact that he, you know, listens and lets me argue and just. They were looking at me funny when I walked in with my tennis shoes. I'm like, no, I'm gonna stay in these as long as I can. Have you been trying a lot of cases or?
No, we've been I think we've had office-wide, 1 homicide so far, and then we tried an aggravated battery and burglary. That's it so far.
No.
So we've been very slow to get going. We've resolved a bunch of cases. But yeah, I think probably August-ish. it's gonna
Pick up.
yeah. Right now, we've been limited to 1 trial a week.
Oh, wow.
Across the whole office. And I don't think they're doing any co-defendant cases or anything right now, so.
Sense. You know, in DeKalb, when we tried homicides, I was mostly in front of Judge Corsi.
Okay.
And he would pick, we would have, you know, jury pools of like 96 people. And he would, at the end of jury selection, usually by the end of the day, he would thank everybody in person by name without looking at the note. It was the craziest thing.
Because I'm not like that at all. Face, I don't forget her name.
I think he had an eidetic memory. He was a partner with Kogo. Not that that means anything, but
So he just confirmed we ran both for everybody.
Oh, okay.
NCIC and G6.
Thank you.
I just, I saw the back and forth, but I missed hearing it today. I was like, oh, I can hear now that the focus was NCIC. That was kind of the issue. So I wanted to make sure that, like I said, that's our practice, but I didn't specifically, yeah, so if somebody does not have an out of state, it's because nothing returned. They
Okay,
included it in the packet if there was a return at all from the NCIC.
okay, so if it just, like when they teletyped it, if it said no criminal history, it just says no criminal
I
history?
think, yes,
Okay.
like I said, I didn't see it, but if you have any reason from what you looked at to think, I don't have something, or you want me to even rerun somebody, just let me know.
Oh, well, thank
But
you.
he ran everybody on both, so.
I appreciate that. Yeah, the last time, I tried a homicide here. It was, I can see her name. She's a prosecutor in Fulton now. I mean, at DeKalb. Yolanda Mack.
Oh, she's back,
Oh, she's back?
she works here now.
She ran NCICs, and it turned out that two of the victims on a 404B case who said that they just knew each other, were actually either brothers or cousins, and had committed dealing in stolen property out of Virginia, but been charged and pled in Miami.
Oh,
Nobody knew, and without the NCICs, nobody would have known. So I flew down to Miami, got copies, got them certified, and then made copies for Yolanda. Defense attorney's like, why do you do that? Just spring it on them. I'm like, no, I don't do that. So if I find anything, I guess is my point, I would give it to you.
Nobody's angel, I'm very used to that.
But that's why I'm telling you the story, is if I find anything and I get certified or I get that information, I'm just gonna follow reciprocal.
Okay, well, I appreciate you.
I appreciate you too. Thank
We'll
you.
talk soon. That date will be here before we know it.
I know, right?
Reach out.
Yes, with a
Let me know if you
number.
have any questions about what you look at when you get it.
I will, and I have to talk to them. Thank you. Bye, Karen.
Bye.